Thank you very much. Welcome to the third public hearing for the inquiry into the acquisition of land in relation to major transport projects. Before I commence, I'd like to acknowledge the Gadigal people, who are the traditional custodians of the land on which the Parliament sits. I'd also like to pay respects to elders past, present and emerging of the Eora Nation and extend that respect to other Aboriginals present and those who may be listening today. Today's hearing is being conducted virtually. This enables the work of the committee to continue during the COVID-19 pandemic without compromising the health and safety of members, witnesses and staff. As we break new ground with the technology, I'd ask for everyone's patience through any technical difficulties we may encounter today. If participants lose their internet connection and are disconnected from the virtual hearing, they're asked to rejoin the hearing by using the same link as provided to them by the Committee Secretariat. Today we'll be hearing from representatives of the Law Society of New South Wales, from impacted business owners, the local member for Granville, and also the New South Wales Valuer General. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the virtual hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it's important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions that a witness can only answer if they have more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days. Today's proceedings are being streamed live and a transcript will be placed on the committee's website once it becomes available. Finally, a few notes on virtual hearing etiquette to minimise disruptions and assist our Hansard reporters. Could I ask committee members to clearly identify who their questions are directed to? And could I ask everyone to please state their name when they begin speaking? Could everyone please mute their microphones when they're not speaking? Please remember to turn your microphones back on, and there really is always at least one person that does this. So don't be worried if it's you, it might be me this time. So turn your microphone back on when you're getting ready to speak, and if you start speaking while muted, please do start your question again so it can be recorded in the transcript. Members and witnesses should avoid speaking over each other so that we can all be heard clearly. Also, to assist Hansard, may I remind members and witnesses to speak directly into the microphone and to avoid making comments when your head is turned to the side. I now welcome our first witnesses. I will ask each witness to please state their name and position title and swear either an oath or an affirmation. And I will start with you, Ms. Murray.
My name is Penny Murray. I'm a partner at Addison's Lawyers and a representative of the Law Society of New South Wales, and I'll be taking an affirmation. Would you like me to do the affirmation now?
Yes, please.
I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Mr. Drury, could you please state your full name and position title and swear either an oath?
Thank you, Chair. My name is Christopher Drury, spelled D-R-U-R-Y, and I'm the Deputy Chair of the Law Society of New South Wales Environmental Planning and Development Committee, and I would take an oath. I swear that the evidence I give before this committee shall be the truth to the best of my belief and knowledge, so help me God.
Thank you. Could I invite you to start by making a short statement? If you could keep it to no more than a couple of minutes, that would be great.
Thank you, Chair. I will introduce, it's Chris Drury, I will introduce our committee, if I may. The Environmental Planning and Development Committee is one of the Law Society's 27 standing committee. Penny Murray and I are two of 15 members of that committee. Our committee monitors all issues, and in particular legislation and court decisions about environmental planning and development law, which includes compulsory acquisition law and compensation issues arising from compulsory acquisitions. We represent the Law Society and its members on policy and practice issues, and our priorities include, firstly, developing and commenting on law reform and legal policy by submissions to and liaising with government and other stakeholders. Nextly, educating the legal profession about changes to the law and providing guidance on practice and procedure affecting our area of the law, and exchanging information about legal trends and new developments such as case law of interest or concern, particularly where there are issues of legal policy arising from case law and the like. And now I'll hand over to Penny, who will talk to our submission.
Thank you, Mr. Drury.
Thank you. As I mentioned at the beginning, I'm a partner at Addison Lawyers, and I've been practicing as a solicitor for 20 years. As a member of the Law Society Committee, I raised the need for reform of the Land Acquisition Just Terms Compensation Act, primarily arising out of multiple issues that I was experiencing on behalf of my clients. And it is as a result of that that ultimately led to the Law Society of New South Wales submission. It does not address all of the terms of reference, but the primary focus of the Law Society submission is that there should be a review into the Act. There has not been a wholesale review into the basis for which you can get compensation for acquisition for 30 years. There has been some reference to the Russell Review in 2004 and the government response to that in 2016, which it is acknowledged did lead to some beneficial changes to the legislation and processes. But the Russell Review specifically excluded consideration of the level of compensation payable for acquisitions of real property. And David Russell actually made a recommendation that there should be further consultation on this. And the New South Wales government response to that in 2016 was that detailed guidelines have been developed for acquiring authorities to ensure a more consistent assessment of business claims, but there was not further consideration of compensation, and particularly for business claims. If there is a review, the Law Society could make submissions at that point, but in the interim, I think there are some immediate measures that could be taken to alleviate some of the stresses in the system, such as provisions for advance payment, acquiring authorities detailing the basis of the offers that they make, and that the 6-month informal negotiation period commence with the issuing of an offer, not a mere letter, and that there be stamp duty dispensation for all owners where they intend to relocate or purchase another property. Chris and I here today are here as representatives of the Law Society, so we can speak to the submission lodged. But for other questions, we may have to take them on notice, or alternatively can provide our personal views, which would not be those of the Law Society. Thank you, Chair.
Thank you very much. I'm going to start questions with the opposition. Is that you, Mr. Mookie?
Yes, thank you, Chair. And firstly, can I thank the witnesses for their appearance this morning, and can I equally thank you for the comprehensive nature of your submission. I might direct these questions at first instance to you, Ms. Murray. You said that the Law Society submission stemmed from your experiences with the system, I presume representing some of your clients, is that correct?
Yes.
Can you take us through what those experiences were which prompted you to bring the need for reform to the Law Society?
Yeah, look, I think some of my personal experiences have arisen out of probably in the last 2 or 3 years. There has been a combination, I think, of case law that has had a stricter approach, if you like, to the interpretation of the legislation, and in conjunction with, I know, an approach from acquiring authorities to be much more conservative, less likely to be willing to engage in a forthright discussion on compensation matters. And at the same time, the market has gone up in particular areas, and so they're negotiating in an environment where the offers did not reflect reality.
So when you say, just step us through step by step, you've made a mention of adjustments to case law. Is there a particular case or decision that you think has impacted on how the system is operating, which we should know about?
Yes, there's been a series of cases in the last few years to confirm that you cannot obtain stamp duty where you are not owner-occupier. I think an informal, more relaxed approach was taken to this until the case law was solidified on this basis in the last few years. So where you have a company that leases it to a related entity for asset protection purposes, or you've got self-managed super funds, or you've got a husband leasing it to the wife's business or whatever, none of those entities can claim relocation stamp duty costs. And I find stamp duty is a helpful thing to sort of convince people that the offer that they've got is reasonable, because if they were sold it on the market tomorrow, they wouldn't get stamp duty, but at least you can say, look, you haven't got everything that you wanted on the compensation on this case, but you have saved money on stamp duty, you should accept the offer. And that's disappeared for many landowners. And I think in this latest round of acquisitions, there were a lot more business rather than residential acquisitions. So this has become a much more prominent issue. And there's been some other cases, such as the United Petroleum case, which talked about the limited extent to which you can claim business sort of disruption, lost profits, and particularly where you have short-term leases, even if they've been historically renewed year after year.
And then the second point you pointed out, which led to you to push for reform, was your experiences with acquiring authorities. Are you finding that there has been a change in the attitude of the acquiring authorities and their willingness to negotiate?
Yes, and I should say, Daniel, that this is my personal experience and not that of the Law Society.
Please.
I think, yes, I have just experienced, I think, since, I would actually say since the Camellia audit and concerns about that transaction and the Commonwealth Leppington acquisition, where there was concerns that the government had paid too much for land, that there has been a much stricter approach to the way in which some acquiring acquisition authorities, not all of them, have been approaching acquisitions.
Do you mean the Transport Department and Sydney Metro, amongst others?
Yes.
And when you say that you think that it coincided with the, I guess, the expose around Camellia, practically what has that translated to in terms of your ability to actually get an outcome for your clients in a timely way, let alone a just way?
I'm finding that the offer that is made, it's very difficult to change their minds. If we've put on material with consultant expert material which substantiates a particular position, if there is no counter position or counter expert on the other side, sometimes there isn't even one because the government hasn't appointed one, then there's no sort of counter expert to counteract that, but there'll just be a position that we're not willing to engage on that particular topic.
But are they willing to share with you the basis upon which they reached their valuation or not? Or is it relatively opaque?
Eventually, once you reveal the detail of your claim, yes, you do get an understanding of where they're coming from. I think that's true.
Look, I'm conscious that I'm going to pass to my colleagues soon, but can you also take us through any experiences you've had with the Valuer General's office? And what are they engaging with your clients in a timely way? Are they sort of providing relief in terms of the ability to at least ascertain the value quickly in order for your clients to make decisions about their commercial and personal interests?
My personal view is that the Valuer General's office has generally been very good. But in the last 6 months, there's been difficulties. There's been a lot of delays. I think with the Metro West acquisitions, I'm not sure of the numbers or whether they've been overwhelmed with the number of people going to the Valuer General rather than reaching agreement. But we have been seeing delays of 6 months to get determinations, and then sometimes 2 or 3 months between a preliminary and a final determination, with the appointment of some consultants who had not done a thorough investigation, and some I would question whether their consultants who were doing the investigation were adequately qualified to make some of the comments that they made.
Mr. Drury, I just invite you to provide any reflections or of your own experiences, either in your own personal capacity or the Law Society's capacity, on any of the questions that I directed to Ms. Murray.
Yes, Mr. Mookie. I would say one of the biggest disappointments that persons whose land is about to be acquired have to face, and we address this in our submission, is that when one receives an offer from the acquiring authority, one receives a letter of offer. One doesn't receive a copy of the valuation upon which the offer is based. And one writes to the acquiring authority and asks for a copy of the valuation, and you're told, no, that's not our policy. And then you either telephone or write back and say, as you know, Section 10A of the Just Terms Act requires that there be a genuine attempt to negotiate an agreed price, and surely a genuine attempt would involve providing to the affected owner a copy of your valuation. And the response given, and this is not just my experience, but I've had discussions with barristers who practice in the area and valuers, the response given is, no, it's on our website. The policy is on our website. Therefore, we must follow the policy and not provide a copy of our valuations unless and until you provide yours, which, as the Law Society submission makes clear, that then requires an affected owner to go and spend whatever it might be, $15,000 or so, to obtain their valuation with the consequent delay, etc. And it may well be that the acquiring authority's offer is based upon a fair and reasonable valuation, and it can save time, money, etc., etc. But with the greatest of respect, one cannot avoid the statutory obligations contained in Section 10A by saying, no, we have a policy on our website. A good point Penny made, particularly I think in relation to Sydney Metro and Parramatta Light Rail and Sydney West, has been that there have probably been a lot of acquisitions and there's been a terribly delayed process of offers being made, particularly from the VG's office, to affected owners for whatever reason. And yes, periods of up to 6 months delay, which impact upon affected owners quite significantly. What can be done about that? But
my last question on that particular point about the VG delay is the VG by law is required to reach a determination within a certain period. Is that correct?
Yes.
And that period, from memory, is it 75 days or is it less than that?
You're on mute, Penny.
Sorry, it can be 45 days, but it can be extended by another 60 days.
So last I checked, the average of the VG for determination was about 115 days. And that there has been a deterioration, I think, from the last available public information. Is it your experience that, in respect to your clients, VG determinations are taking place outside the timetable that is permitted by the law?
Yes.
Yes.
Thank you, Chair.
Thank you. I will throw to Mr. Banasiak first, because I think I left him out yesterday at one point. Go ahead.
Thank you, Chair. Just picking up on the point that you made, Chris, about the first letter of offer just being a letter of offer. Would you suggest that we actually legislate that the so-called first letter of offer must contain a valuation report that can then be assessed by the opposing party?
Well, it's my understanding, and the latest experience I had where we eventually did get the valuations, is that the offer is made by reference to a valuation. So if the acquiring authority has a valuation, I would have thought that the genuine attempt to negotiate must impart an obligation of good faith, even though those words are not used in the legislation, perhaps deliberately so. But I would have thought that it's in everybody's interests for the offer to be accompanied by a preliminary valuation, and it can be just that. It does not need to be a valuation that has the same legal effect as the Valuer General's valuation, but it can help to inform and assist persons affected by a proposed acquisition.
Okay. Just picking up on your brief comments in your submission on, I guess, the uplift in value, and you state that it's more a matter of revenue generation and taxation than being related to compulsory acquisition. But would you accept that, with that uplift in value that may come from partly the improvements that are made with further amenities, that it sort of does become an issue in compulsory acquisition because the person who is being having their land compulsory acquired finds it quite difficult to, I guess, find a like-for-like or similar dwelling in a neighbouring suburb or that suburb. So it is in fact an issue that is related to compulsory acquisition.
Penny can speak more to this than me, but the point, Chair, that the committee member makes about the difficulty of owners finding like for like is probably one of the most significant problems that affected owners face. And it's not just residential owners, but it's business owners as well. You know, if you have a warehouse in a particular location A, it doesn't necessarily follow that you can easily find another one nearby. It's a big problem.
Just on that point, Mr. Jury, do you think we should have, I guess, separate procedures or more well-defined procedures for commercial properties that are acquired over residential? We've heard some submissions that they're obviously two completely different beasts. Do you think we should, perhaps separate out commercial properties as a separate process?
Well, I think this is part of the Law Society's suggestion that there needs to be a look at the Act as a whole. And I might hand over to Penny in this context because Penny's got some particular and detailed experience with positions.
Look, I think from the Law Society's point of view, we've said there needs to be a review. I don't think we've necessarily got all the answers as to whether they should be split into two separate processes, but I would say that it's definitely a very different compensation assessment process for a business relocation and compensation claim that it is for residential.
Okay, I think I'll pass back to you, Chair, if you have a few questions, just to share the love.
Thank you. In terms of just picking up on that point, in our discussion yesterday with Sydney Metro, and we've heard this a lot from government agencies when we've asked these sorts of questions, we hear that, they're doing everything in accordance with the Just Terms Act. To what extent do you see the processes, attitude, and perhaps even culture of some of these acquiring agencies being, I guess, outside of the spirit of that Act? To what extent could they improve their processes before we actually change the Act?
I think things like advance payments, because there's been huge delays with a lot of the Metro West acquisitions this year. Some people have not had compensation for 6 or 7 months for the land that they've been taken from them. They've incurred all these costs, including legal and valuation costs, but also relocation costs with not a cent of compensation, continuing to have to pay their mortgages, not receiving rent from premises if they were rented out to tenants. And then the interest under the Act is 2.2 something percent, but the land prices are going up 2% per month. So they're having to buy replacement properties in a market that's completely different to the land that it was taken in. And some of them are having to look to move from, say, Westmead, Clyde area to Emu Plains to get equivalent land at the price for which they receive compensation. And the other thing that's also within the power of the authority is whether they charge these landowners rent and the terms on which they continue to occupy. So one of my clients has incurred $100,000 worth of rent because that's what the government said they would have to pay rent whilst they were in occupation until they found premises. Once they found premises to relocate to, they would not be charged rent, so they didn't have to pay twice. But they've been waiting for the VG's determination before they would move because they wanted to know how much money that they would have. And so rent was imposed. And when I asked, how did you come up with this rent amount? There was no discussion as to the amount. I approached them before the gazettal to say, what are the terms of occupation? The Act suggests we're meant to reach agreement. And in the absence of agreement, you can dictate the terms of rent. There was no discussion as to what the terms of occupation would be. We were just told 2 days before what it will be. And if you don't accept it, then basically if you stay on the land, you're deemed to have accepted the rent.
Wow.
So there are things like that that could be improved.
So, yeah, right. So that's, just to clarify then, so we heard yesterday from a number of residents, and I've had many discussions with impacted residents across the state for various projects who have described the heartache that they've experienced through this acquisition process, and the uncertainty, the emotional distress, the financial strain. Are you saying that there is an element of that is caused by discretionary actions of the government? It's not necessarily something they were required to do under the Act, that they could have actually made the lives of these people easier?
They definitely, under the terms of the Act, have the power to charge rent, and they are choosing to charge rent. And for some of these occupants, they were owner-occupiers, so they'd never paid rent before, whereas others were paying rent to a different landlord. And so I guess in some sense they were used to be paying rent, but some had never paid rent. So they were having to pay their mortgage for land that had just been acquired and now have to pay rent as well.
But that's not required under the Act. That is a discretionary decision.
Yes.
Thank you. Do you think that the obligation to, negotiate in good faith extends to ensuring that the particular people that you're dealing with have sufficient resources and knowledge to engage in that negotiation? And I guess I'm picking up on that point that Mr. Bonacic raised about the difference between a sophisticated property investor, or property developer that you may be acquiring land off, versus someone whose family home is being taken, who might not have any sort of legal or financial experience. Does the obligation to ensure sort of, a reasonable attempt at negotiation extend to considering that difference, do you think?
Well, the Act uses the word genuine attempts. It doesn't use the phrase good faith. Look, some acquiring authorities will make advance payments for legal and valuation costs to give people the ability to incur, to get that advice to respond to the offer. But I think in this submission we talked about how it's not a consistent approach And also the extent of the advance payment's not consistent. So sometimes it might be they'll say you can spend $2,000 on getting a valuation, but you've gone to a valuer and the valuer is telling you it'll cost $5,000 or a little bit more. So there's not a consistent approach as to whether you'll get advance payments.
Thank you. My time's expired, so I'll run to the government. Is that you, Mr. Farlow?
Yes, it is, Ms. Boyd. Thank you very much. Just interested in terms of, I think your submission talks about, of course, Section 56 and the definition of market value. Does the Law Society take any view as to any amendments that should be made to that definition or its suitability?
Not at this point. We think there should be a review and a wholesale consideration of whether the Act is working.
So there's no position that the Law Society would take on that. It's just captured in terms of a broader review. Now, I think you mentioned as well previously, Ms. Murray, about the change in approach from Transport for New South Wales when it comes to acquisitions because of the issues that have happened at Camellia and the like. It's sort of a case, I guess, of damned if you do and damned if you don't. So those instances are where obviously it's reported or suggested that Transport paid over market value. And of course, we've been dealing and hearing with certain instances through this inquiry where it's suggested that the offers from Transport for New South Wales are perhaps, well, I wouldn't say under market value, but a fair market value from what they are determined at present, but don't capture any uplift. What do you think can be a better process to try and address that gulf between both situations?
Look, I think that's why the Law Society is saying that there needs to be a review. I have personal views about the process, about the choice of valuers, for example, that the government's using. And I think in the current market, particularly with the industrial market last year, the valuations which were done by the government were out of date. So if they had been brought up to actual current market, and even when you're assessing market value for an acquisition in March, you tend to be assessing it in January. So you're never really up to date almost until after the event. So even if they just brought their market values up to date, that would be helpful.
Thanks very much for that. Mr. Mallard, anything from you?
Mr. Farlow, and thank you for coming in this morning and your submission. I just wanted to touch on, first I wanted to just clarify the Russell review. That was 2000, I think you said in your, I might have misheard you, you said 2004, but my records say 2014, is that right?
14.
14. Okay. I just wanted to clarify that. It's a long time to have a review sitting on a desk and then turn into legislation. And you say it delivered some positive outcomes when the current government legislated to do some reforms. Do you want to just point us through the positive side of it? We heard a lot about the negative, the positive reforms that occurred out of that 2000 and what year was that that we did that?
So 2016.
16, yeah.
So there were things like the 6 month informal negotiation period, which was mandated with the genuine attempts to reach agreement. That was one of the reforms. The solatium payment, which is the emotional distress payment for people who are occupying their house when it's taken, that did increase, and it stayed at the same number for a while. And they also introduced a provision to talk about reinstatement. So if there was no general market, there was no market value for your land, you could claim reinstatement.
Into the community.
I'm not sure how often that's been. I'm not sure how often that's been used.
Heaven forbid they have to go to Emu Plains, so they can go back into their local. I came from Emu Plains, so they go back into their local community. I get that. Yes. There was a little
yes, but it does have limited application because it talks about where there's no general market for the land. So
yeah,
I don't know if it's really meant to apply a lot of the time to residential ones, because you'd say that there is a market for residential dwellings in a lot of the cases.
So you're saying?
I was going to say, apart from the legislation, there were improvements in procedures. I think for residential, they did appoint case managers. There was that acquisition centre that sort of would help, I think, people who are very overwhelmed by the process. But that sort of case manager approach doesn't really work very well for businesses. I haven't really seen that been applied whenever my clients have rung them. They haven't really found much assistance from them in a business context.
Mm. And you're saying that the area that didn't address, in your view, adequately, your society's view adequately, was tenants and commercial. Now, we pretty much see commercial be pretty good at looking after themselves going to court. I've seen a few pretty significant court wins in terms of the West Connects. But tenancies, and particularly residential, are they falling between the cracks here?
You mean residential tenants?
Yes.
No, I don't believe so.
Oh, so they're relocated, and there's a process that's fair and reasonable for that?
Yeah, they get their relocation costs, removalist costs, that sort of thing. I think you've got to be careful though about businesses and assuming that they're the big guys. There's a lot of small family businesses that have been, acquired who would not be the ones who would be willing to take things to court, but have felt that they can't buy back in to the industrial area in which they were.
How long have you and your colleague here been involved in this area of law?
I've been doing it for about 20 years.
Okay.
Chris has doubled me.
Would it, 20, 40 auction? Would I be right to say that, it's a factor of the current government since 2011 and the incredible boom in infrastructure that we've been doing, that you've had a greater caseload in terms of this area, because it's just a factor of the multiplier, the fact that we need to acquire more sites for so much more infrastructure?
I think that's a fair comment. And interestingly, somebody from Sydney West Metro said to me that we really are doing our very best to put pressure on the Valuer General's office to get valuations out, but we can only do that. We can only put pressure on them. And he said, we in fact have demanded that at the relevant time, all valuations be completed by a date. But all they could do was, to use his words, demand. It didn't happen, of course. But yes, I think that's a fair comment. There's a lot happening.
That could be an issue there, resourcing the Valuer General's office then.
Well, of course, the Valuer General, it retains private valuers to do the valuations. But I was doing this 40 years ago, and my experience was that the Valuer General's office per se was a bigger organisation then and a different organisation then to what it is now. And although not in our submission, it's also possibly important to bear in mind in terms of, the pressure upon valuers, that a lot of valuers did leave the industry over a period of time because they had suffered pretty unpleasant experiences in cases before the court where they could be cross-examined for days on end. And this was many years ago, but a lot of very good valuers did leave, sorry, not so much leave the industry, but get out of doing that sort of work, the court work. And if you're not going to do the court work, they wouldn't do the preliminary valuations and so on. So that was a bit unfortunate. And so yes, I think there's a resource problem.
No, I certainly wouldn't want to be a valuer. I mean, the fast-moving market, the pressure from banks and finance to get the information correct, and then the people trying to borrow the money have got their own expectations. I've been there myself. It must be an incredibly stressful profession.
The other thing to keep in mind for business acquisitions, particularly for tenants, is it's actually more about less valuation and more about quantity surveyors and that sort of thing, about what's it going to cost me to pack up and move and set up somewhere else.
Okay. Well, that's all my questioning, Madam Chair, but thank you very much. Thank you for your answers there.
Excellent. We have, in fact, run out of time, unfortunately. Thank you very much for attending and for giving us the benefit of your knowledge this morning. If there were any questions taken on notice, I don't believe they were, but if they were, or if we have any supplementary questions for you, the Committee Secretariat will be in touch, and there's 21 days to return those. I thank you now and say goodbye, and we will move to our next session.
Thank you, Chair.
Thank you. Mr. Walsh, can you hear us?
I can.
Very good.
Hear me.
Yep, excellent. Okay, let's get started then. Thank you very much for your attendance today. If I could get you just to start by telling us your name, position, title, and then swearing either the oath or the affirmation, please.
Sure. My name is Christopher Walsh. I'm Head of Property at Heworth Holdings. Let me just bring up the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. Would you like to commence with a short opening statement?
Sure. On behalf of Heworth, I'd like to thank you, Chair, and members of the committee for the opportunity to address you all and ensure that you are properly informed to the fullest extent about Transport for New South Wales' unreasonably protracted attempt to acquire our development site at Rozelle and the many flaws within the Just Terms Act that has allowed these events to unfold. There is a letter that we wrote to the Honourable Andrew Constance, at the time the Minister for Road, Transport and Roads, in October 2020, which best describes the convoluted acquisition process and our frustrations pertaining to it, which I provided to the committee for their benefit, so I will refrain from going into the same detail here. There is also a letter to the Secretary of Transport for New South Wales the committee may find beneficial. However, by way of background, Heworth purchased the iconic site on Victoria Road, the former home of the Balmain Tigers Rugby League Club, in late 2017 and lodged a development application shortly after. RMS first advised Heworth they would likely require temporary use of the site as a construction site for the Western Harbour Tunnel and Beaches Link project in March 2018. Transport for New South Wales publicly announced the proposed acquisition in July of the same year, with the Western Harbour Tunnel environmental impact statement study confirming our site as the project's dive site in January 2020. Subsequently, once the EIS went on public exhibition, Heworth paused all critical development activities such as off-the-plan sales and marketing on the basis that the site would be acquired imminently. The DA was under assessment at the time, so it was progressed and achieved development consent in September 2020. The cornerstone of the 28,000 square metre mixed-use development was supposed to be a new Tigers Leagues club. In line with the state government's COVID economic recovery plans, the site's development would have created over 1,000 jobs during construction and its ongoing operation, and was expected to generate almost $60 million a year in retail sales. It wasn't until May 2021 that Transport for New South Wales finally issued a proposed acquisition notice, or a PAN, seeking to acquire a 7-year lease of the site. In the recent budget estimates hearing, Transport for New South Wales in fact conceded that tenderers for the Western Harbour Tunnel project may have their own preferred dive site rather than our Rozelle site, which might explain why a simple acquisition has taken Transport over 3 years to reluctantly issue a PAN for. The acquisition was gazetted last Friday on the 1st of October 2021, with an assessment of compensation now to be determined by the Valuer General. In my view, not only has Transport for New South Wales failed to make bona fide attempts to reach a settled outcome, but it has repeatedly and significantly delayed in providing offers of compensation, such as to frustrate the acquisition process and draw out negotiations. The fact that Transport for New South Wales has not ever provided an open offer of compensation and has not provided any offer of compensation for market rent in over 13 months is but one example of the lack of good faith they have exhibited and delay tactics they have used over the last 3.5 years. This is despite the statutory obligation for Transport to make a genuine attempt to acquire the land by agreement for at least 6 months before giving a proposed acquisition notice. As a result, Heworth has incurred over $1 million in professional fees, approximately $15 million in holding costs, and has suffered a 21-month delay to the development program. I'd like to note that none of these costs would have been recoverable if a PAN was not issued. The conduct of Transport for New South Wales as a whole is simply representative of how heavily weighted the Just Terms Act is towards the acquiring authority and how a landowner's rights are dependent on a box-ticking exercise with no real certainty until the final hammer falls. There are many areas of the Act that require urgent review, and I hope any answers I provide to your questions will assist in a fairer and a more equitable and just compulsory acquisition system being adopted in New South Wales. Thank you.
Thank you very much, Mr. Walsh. I will start with questions from the opposition. Mr. Mookie.
Thank you, Chair. Mr. Walsh, can I just ask you at the outset, firstly, thank you for your appearance, but what has been the effect of the delays on the actual club and the community members and the supporters of the Balmain Tigers as well, as a result of the delays that you've described rather comprehensively in your opening statement?
As outlined in our submission and some of the things I've touched on in the opening statement, the development was to help secure the financial viability of the club. However, the protracted acquisition process we have endured has jeopardised the entire development, also the reconstruction of the club and our monetary contributions to the local infrastructure and community grants. The club, who is not alone, is left with another saga of uncertainty.
And you made the point that you got development consent in September 2020. I mean, I think lots of people on this committee are familiar with the sort of ins and outs of the turmoil that led to various other proposals for the site. But it was the case, is it not, that it actually was a development consent that was given by the department, but also had the support of the local council, the club, and it finally brought a bit of resolution about the future of that site. Is that fair?
That's correct.
Can you just tell us as well, why do you think Transport for New South Wales has behaved this way? And I mean, you've described a 4-year process to acquire one dive site for one project. I mean, why do you think that they have engaged in these sort of, this behaviour?
My understanding is that, firstly, all other properties earmarked for the acquisition relating to the Western Harbour Tunnel project have already been acquired. So I can only assume that Transport either cannot say with 100% certainty that they actually require the site, which is what we have been led to believe, or they are uncertain as to when the Western Harbour Tunnel project will commence, and as such have attempted to somewhat kick the can down the road for as long as possible. I'm not going to speculate as to why that may be, but this is a site that has a development that with a $400 million gross realisation value to it. It is not a cheap site to rent. So perhaps budget constraints or OPEX constraints have prevented them from proceeding earlier.
By OPEX, you mean operating expenditure?
Sorry, Mr. Mookie, can you repeat that again?
By OPEX, just for Hansard, you mean operating expenditure?
I do, yes.
Yeah. Look, just my final question before I pass to my colleague is, I mean, I asked the questions in budget estimates about whether or not there was an alternative site that Transport for New South Wales was considering, that you made reference to in your opening statement. Have you heard a suggestion from them or others that they are actually looking for an alternative site that, if they proceed with, they could have avoided putting your business and the Tigers through this turmoil?
Around the time that the PAN was issued, Transport did acknowledge that they had been speaking with some early contractors, as in early contractor involvement or engagement, and that they weren't certain that one of those contractors or tenderers may propose an alternate site and through a value engineering solution and tunnel from an alternate location. My understanding is there is a contractor at Rozelle Interchange that really would be the only alternate viable solution to tunnel from there, but I don't know any more than that as speculation.
I'll pass to my colleague. You're on mute, John.
Thanks for your submissions. When was that discussion that you had? That was around the time that the property acquisition notice was issued?
I believe so. Yes, I need to check exactly when that was, but I think it was about 3 or 4 months ago.
Yeah, so it's speculation at that point, but from your point of view, very expensive speculation given the value of this site.
Exactly, and this is, at that point, it had been a 3-year ordeal and protracted process that we had gone through with Transport. So to find out then, that far into the process, that they may in fact, at some point in the future, whether that was 12, 18 or 24 months later when a contractor was engaged, may not need the site, was incredibly frustrating and off-putting.
That discussion was in around May this year. As of today, is that still a possibility that, in fact, the value engineering solution, the cheaper way to do this, the more effective way to do this might be from another site? Is that still possible, or has that been ruled out as an option?
I'm not entirely sure whether that is in fact possible. That would be probably a question that the Western Harbour Tunnel project team would have to answer. But based on what I've heard, that there is a potential to tunnel from the Rozelle Interchange, and that until the Transport's formal tender process has been completed, that they will not have complete certainty around that.
And if the preferred dive site is elsewhere, what do you know, or what have you been told about what that means for your site?
We have been told nothing. We don't know what that means for our site. We don't know if that means we get paid compensation for the financial cost that we've incurred, whether we get to recover the financial burden and cost / loss that's associated with the 21-month delay in our project program. or whether we get nothing. I believe the plan protects us with providing some level of compensation, but there are many elements and heads of compensation that, i.e. disturbance is one example, that that is quite vague and does not necessarily cover all aspects of financial cost.
But what you're describing there are just basic business, that's basic business information that you need to make the decisions you have to make at your end. And you've just been able to get none of that information in these discussions.
Very limited, constantly changing timelines. So when we first met with Transport in early 2018, they were proposing a construction commencement date, I believe, in late 2019 or early 2020. They are now talking about late 2022.
Late 2022 for the construction commencement. Yep. And when was that? When was the last time you heard that update? How recent is that information?
That was in a discussion about 6 weeks ago.
Yeah. Oh, very good.
Directly from the project team.
Yeah, from the project team to your business. Yeah. Thank you. And I mean, what's at risk here? 1,000 jobs, $60 million in retail sales. Is that gone for good? Do you have aspirations down the track, given all the uncertainties you're facing? Is that opportunity lost forever, or is there a chance, if you're given some certainty, to recover that down the track?
I think our intention is always to be to develop the site. The uncertainties around the length of the lease. Now, there's nothing stopping Transport from, well, they have now acquired the site on a 7-year lease, but there is nothing stopping them from issuing a further PAN in 6 years' time, saying they need the site for a further X number of years if their program blows out. I would say with every year that goes by beyond that 7-year period, it becomes more and more difficult to deliver on the existing development proposal.
Yeah, and meanwhile you have to maintain the sort of plans for the site, all that, keep your systems in place, ready to go, without any of that certainty, and in the face of what is, you'd have to describe as very poor communication.
That's completely right. We would have to carry the financial burden of the site, continue to engage with the stakeholders that signed up to this development when we first lodged our DA, which are all fantastic stakeholders. However, with time, people, things change, plans change, people's interests change. I would hate for the club to find or need to find an alternate site than their traditional home if they're forced to stay and sit in limbo for another 7 years.
Thank you. I'll pass to the chair.
Thank you. Just one quick question, then I'll hand to Mr. Banasiak. Would it be fair to say then that Transport for New South Wales have been effectively keeping their options open at your expense?
Yes, very well put.
Right. That seemed to be the summary. And not just your expense, but also the expense of the community, the club, the whole range of people. That's an extraordinary power for the government to have. and to be able to exercise that in such a damaging way. From your understanding, is that really a product of the Just Terms Act, or is it the manner in which the government is using its powers under that Act?
I think it is probably a hybrid of both. The Just Terms Act has some grey areas. I have got to know it over the last 3.5 years, but there are still many areas I do not understand. We have a great legal and valuation team behind us, and even they sometimes there are question marks over what fits within squarely within the Just Terms Act, or how the Just Terms Act can be interpreted. I think there are flaws in the system, and when I say the system, I do mean the Act, and that simply allows Transport, who is well seasoned in that piece of legislation, to know how to exploit the shortcomings of it.
So more, yes. And I think that's what we're hearing is from a range of people really, is there's this, there are, of course, these powers under the Act, and there are restrictions under the Act, but there are also a number of discretions in how the government chooses to use the powers under that Act. And in this case, as you have so well put, it does appear that it is using that power to keep its options open.
Yes, it's as an example, we pushed them to issue us a PAN after 2.5 years of discussions, because we had no certainty around where this acquisition was headed. Yes, it had been publicly made aware in a lot of documentation, a lot of media. However, as I pointed out before, the Act does not cover compensation payable if a PAN has not been issued. So 2.5 years into an acquisition process, for a landowner to carry those costs and to carry them without knowing whether they would in fact be reimbursed, I think is a clear indication of a big gap in the Act itself.
Thank you. Mr. Banasiak.
Yeah, just I may have missed it, Chris, but how much had you invested at the time when they first approached you and said that they were looking at a leasehold on the property, in terms of, obviously, I think you got to the DA stage, but DAs vary in costs. How much had you invested at that point?
About an all-in cost of about $90 million. That's including the purchase of the land and all development costs to date. Okay,
and that has continued to grow, obviously.
That has.
Do you have an estimated figure as what it is today?
It is in excess of $100 million. I believe it's close to 108, 109.
Okay. In your submission, you talked about how you don't think that the agency made bona fide attempts to reach a settled outcome despite your company's genuine attempts. Did you get any indication as to why they weren't budging on, in their position? Because obviously you said you made genuine attempts, so which that insinuates you were obviously trying to negotiate and come to a landing, but they weren't moving at all. Is that the case?
Yeah, a lot of the discussions over the years have taken various forms. Some of them have been talking timing, others compensation or market value and rent, and others terms of a lease. We try to engage and be as transparent as possible to Transport for our unique position. It is, I'm led to believe, rare that you would, or transport would typically acquire a leasehold over a development site with a looming development approval, or now in fact with a development approval, because it is a costly exercise. Transport has, I probably should just say that there are without prejudice discussions that we have had, which I can't go into at this point.
Sure.
So I'll do my best to not jeopardise them, but still answer the question. So transport has a valuer. We have our own valuer. Our valuers have not been able to come to an agreement on a number of outstanding items. We in fact have retained an very experienced valuer that is often retained by the government on a number of their high-profile acquisitions. And the fact that he cannot convince Transport's valuer of points that he is typically forced to consider when representing Transport himself has just added to the frustration that there's clearly been no real desire to progress a settled outcome here.
Yeah, we've received submissions, and I think we've heard evidence that it sort of equates to almost like a war of attrition, and not necessarily a process of acquiring the property, but a process of deprivation of that property right. Would you agree with that sort of sentiment that we've heard?
I would. Yeah, I think after 3.5 years, we have been worn down. We have tried to come up with creative ways of finding a middle ground between both parties. And at every turn that we have made, we have been faced with roadblocks from Transport. They may take away a proposal that we have put forward to them and spend 3 to 6 months considering it before providing us with any real response. And when we do receive a response, it's generally a negative one, that they cannot consider such a proposal, and we're back to the starting board. I would also add that when I say that we have put forward proposals, we are here on we are not here by choice. It's a compulsory process. We were faced with the prospect of this acquisition, so we simply sought to try and reduce the impact on our business as much as possible.
Thank you, Tris, and Chair, that's all my questions, so I'll throw back to you.
Thank you. Just one last one before I go to see if the opposition want to come back in. We've talked about the amount of cost that you've borne as a business. What about the time resources? Could you estimate how much of a distraction, I guess, this has been from your other business?
I probably have spent on average a day a week on this acquisition for the last 3.5 years. That's 20% of my capacity in my current role, and my time is not compensable.
Yeah.
That doesn't include involvement from the board or the CEO level. So our time is lost. There's the actual financial. I'd love to put a monetary value to my title, but I won't do that. The financial cost in terms of professional fees has come close to $1 million. That's made up of legal, valuation, advice, specialist consultant advice, forensic accounting, all of these consultants that we have needed to understand the process and to consult with transport. None of those costs are necessarily guaranteed to be reimbursed. Some of them most certainly will. Others may not be considered that they fit within the Act. The time delay that we have suffered, that's a difficult one as well. As I mentioned, we paused critical development activities in January of 2021 once it became clear to us that the site was needed, which we considered was when the EIS went on public exhibition. Transport will argue that we did not have a DA approval until September of that year, and in fact then could not have proceeded with our development until that point. However, that's not how projects work. That's not how our business typically works. So there's also no guarantee that we will make up that lost time. We're talking holding costs of circa $10 million a year all in. So every month there is a sizable cost that we incur on this site, and I can assure you I'm confident we will not wholly recover those.
Thank you. Mr. Mookie?
I will just pick up from there. Insofar as you have financed this and financed the cost, has this affected your ability to access finance, or is there an abundance of lenders who are prepared to lend money against a site that the government is about to take from you?
That's an interesting question. Typically, there should be a long list of financiers looking to step in and provide debt on a government-backed lease. But this lease has a 1-month notice to terminate clause, which means it's regardless of whether it's 3 or 7 years, there's no minimum term. The lease could commence tomorrow and be terminated the following month. No lender wants to lend with that much, what they call exit risk. So we're now faced with the prospect of needing to refinance and restructure the existing debt component on this project, either with further equity and capital raising on that front, or some alternate approach that we haven't considered yet, but we'll have to seriously consider now that the acquisition has been gazetted. So that, in fact, probably comes close to tripling our finance cost just on our debt component.
You're describing what I think is termed a stranded asset, is it not? Effectively, financially, and in your ability to use your capital invested here to borrow against. It sounds like you can't, and the asset is in fact stranded. Is that fair?
That's very fair. We cannot redeploy any of that capital unless we can unlock more debt, and we can't unlock more debt without attracting a higher cost, as in interest cost. And under the Act, we are required to reduce our cost as a result of the acquisition as much as we can. So while we would love to take $60 million of equity out of this project for the next 7 years, redeploy it so our business can continue to do what it does, that money is frozen there because we can't raise any further debt against it.
So I can only presume that you have been aggressively trying to reach some form of a resolution with Transport for New South Wales. I mean, I respect the fact that some of these negotiations might be on a without prejudice basis, but can you actually describe your dealings with them? Have they negotiated with you in good faith? Have they been responsive to the offers that you've made? Have they provided detail around why they're taking the positions that they're taking?
Look, definitely in our opinion, they haven't approached these negotiations in good faith. I think the timing, the protracted process and timing is an example of that. If Transport really wanted to acquire this site, they could have done so in under 12 months, with or without negotiations in place. We have had multiple rounds of open and without prejudice discussions on how this leasehold acquisition may proceed. Transport has continuously stuck to their position and, in my opinion, has somewhat hidden behind their valuers' methodology and inputs into their valuation approach, and have simply refused to consider any of our unique inputs or situation when looking at this acquisition. This is not a typical acquisition. This is not a piece of industrial land that remains vacant where there's no plans to do anything with it for the next 10 to 20 years until it's rezoned into some highest and best use alternate. This is a site that should be returning a strong annual project return, and that's just not captured in any of the offers or positions put forward by Transport.
So you made reference that you're intending to pursue now your right to have the valuer general reach a determination. Are you considering any further action beyond that stage?
I believe the process is the valuer general provides a determination on compensation. If we're not happy with that compensation, we will go to court, and we are prepared to do that. Such as I think Dasani did. However, at this point we have every faith in the valuer general to look at this project and consider the unique elements of the site and consider the well thought out positions put forward by our valuers and our legal team.
So, I mean, look, I know you probably can't answer this, but I can only presume you can speculate, given you are the counterparty. But I can't imagine that this process has been cheap for taxpayers and the Transport for New South Wales side either, has it? I mean, I presume it's not some junior clerk you're talking to. It's a lawyer, valuers. It's quite an expensive process for taxpayers in terms of who you're engaging with.
Very. I don't obviously have the numbers from Transport's end. Like I said, we have incurred simply $1 million alone in professional fees. there will be compensation payable for the disturbance between when we cease development activities up to the point of gazettal. The taxpayer will be left to carry that cost. And from Transport's end, I believe they have a valuer who has been engaged for three plus years, a very experienced legal team, senior, imagine some kind of senior counsel, and they are now peer reviewing a lot of the evaluation work, which would also be a costly exercise.
And we heard evidence this morning that this was there's been a change in the demeanour of Transport since the Camellia matter was exposed, which, to be fair, I had a role in. Have you noticed such a shift?
I have. And this is my personal opinion based on the experience with Transport and the discussions, but it feels like, or appears that Transport has become more cagey and reluctant to engage, to make any decisions since the last inquiry, and I believe a lot of the media attention that Camellia attracted this time last year. No one seems to want to make a decision in Transport because it's safer to stick your head in the sand and hope the problem goes away.
I mean, that was look, for what it's worth, I indulge a little bit. I mean, I'm slightly unapologetic for having brought to the attention the inability of that agency to follow the law, which led to a massive overpayment. But we've been told by the Secretary and others that the procedures have now been cleaned up, the policies are in place, that the review that the Minister ordered has resulted in changes to the procedures, and therefore we can have, and Transport can proceed with confidence that the way in which they engage is now consistent with the law, which it was not before. But that's not your experience, is it?
No. The example I gave in the opening statement where Transport is supposed to engage or make a genuine attempt to negotiate before issuing a PAN, or at least 6 months before issuing a PAN, is one example of that not occurring. Probably another would be, look, I think the Just Terms Act itself has these flaws where there are no timelines for Transport other than to issue an opening letter at some point, and then to 6 months later, in theory, or a minimum of 6 months later, issue a PAN. Other than those two timelines, there is nothing else in the Act, from my knowledge, that requires Transport to progress an acquisition within a minimum or even a maximum time frame. And we are the perfect example of that 3.5 years in. Our legal team, who have worked on many high-profile compulsory acquisition cases, have said that they have never encountered such a prolonged acquisition in their entire experience. I would add our valuer to that as well.
Chair, I think our time might be up.
It is, unfortunately. Thank you so much, Mr. Walsh. It's been extraordinary to hear what you've been through, what your business has been through over the last few years. Incredibly helpful for the inquiry. Thank you very much. If there were, I don't think there were any questions taken on notice, but if there were, and if there are any supplementary questions, the committee secretariat will be in touch with you, and you'll have 21 days to respond to those. we're going to take a very short break just to allow people to grab a cup of tea or coffee. We'll be back at 11:03 for our next session. Thank you.
Thank you, Chair. Thank you, committee members. All the best.
Yes. Okay, thank you.
Hurrah! Fantastic.
Sorry about all that. It's very tricky.
Yes.
And I can't minimize screens because if I have the laptop open, which is the only thing with a camera on it, it has the same image across 3 different screens. It's very...
Absolutely, yes. Understand, can relate. So no worries at all. Let's get started. Now, we don't need to swear you in because you are, of course, a member of Parliament. But would you like to give a short opening statement to the committee?
Yes. So in my time in Parliament, I have dealt with many people affected by the compulsory acquisition process. I didn't go into Parliament being someone unfamiliar with compulsory acquisitions. I was the Lord Mayor of Parramatta and a councillor on Parramatta Council for many years during the whole period of the acquisitions of the land where Parramatta Square is now being built. I was on the management committee for the acquisition and development of that site when Parramatta Council was taken to the High Court. I remember asking lots of questions of our legal advisors and property advisors about whether or not that was, shouldn't we just try to negotiate, and being told, no, everything's fine. We've got legal advice. So I'm very familiar with the Just Terms Acquisition Act and how it's played out with different people over the last 20 years and what those changes to the Act have been. If you like, I can go through this historically, because I think for background it's good to hear about the WestConnex examples, because there were those changes to the Act made by then Minister Perrottet, now the Premier, which was supposed to fix everything, and I don't believe they really have. So when I was first elected to Parliament, the first properties were being acquired for the M4 widening project at the very start of WestConnex. They were a combination of compulsory acquisitions and then acquisition by negotiation of properties which were not on the site where the widening was occurring, but were severely adversely affected. So losing more than 50% of their sunlight, huge noise impacts, cracking and disturbance, those sorts of issues. They had tried, back then, they sort of had this good cop, bad cop approach. They'd send 2 people out to the site. It seemed quite unfair at the time, and there was a lot of adverse media about it. And we would have hoped that that would have all been resolved by way of all those changes brought in afterwards and after the Russell review. But it seems that they weren't. Things were far, far worse with the acquisitions done by Sydney Metro. So, and just to give you an idea of how bad things were with WestConnex, for one of the compulsory acquisition properties, a family that I know quite well, and I still know, and I used to live very close by, so I actually knew them because I used to walk past the house all the time. They had built an illegal granny flat in their backyard. They're not greedy people. They're a very, very large Lebanese family who lived in a very small fibro 3-bedroom house where they had 6 kids. So they built a granny flat in the backyard. When they tried to get it approved by the council, the only objector to having it retrospectively approved was RMS. And the only reason they gave for the objection because it would increase their liability when purchasing the property. When it came time to purchase the property, they refused to give them any compensation for the value of the granny flat because they just gave up on trying to get it approved by council, and council never made them demolish it. So they left it there until it was compulsorily acquired. They were also then given only, once the valuation was agreed on, they were given only a few weeks to move out, even though it was over Christmas. and it wasn't until I had them on Channel 7 that they got an extension, and they were going to be charged well over the market rate for renting their own, what was essentially their own home, until I found a new place. With the ones done by negotiation, the biggest issue there was once they finally achieved what they thought was a fair value price for their properties, it was in the time of a really rising market, and they didn't end up getting their compensation usually for about 6 months after they'd agreed to terms. Then you're looking now at what's happened with West Metro. I'll start with the residential properties. They're a bit more simple, but everyone living in those properties in Westmead received a notice that they were going to be compulsorily acquired in about November, December of 2019. And under the new rules, there's a 6-month period of negotiation, and this is what they were advised in their letter. And then no one, even though the government claims that they have relationship managers to look after this and they'll be constantly communicating with you, no one spoke to any of them again until the following May, so about 3 weeks before the final deadline, and they received their first and final offer, which was a lowball offer in all cases. Their explanations were terrible. So they basically gave most people who owned a 3-bedroom unit the value of a 2-bedder in Westmead. And they used excuses like, oh, your apartment block is old. If it's just terms compensation, it should be like for like. You should be getting the price of a 3-bedroom unit for a 3-bedroom unit. So they could buy a 2-bedder in Westmead, or the closest 3-bedroom unit they'd be getting is maybe at Blacktown, but probably at Mount Druitt. They were really, really bad lowball offers. The people who lived in freestanding houses got the value of offers at the value of the home in its current condition, not the maximum developable value of the land, which is what you were supposed to achieve under the Just Terms Acquisition Act. And now, remembering that once the metro is built, there's going to be high-rise units put on these properties. So nobody achieved what they should have achieved. No one achieved anything more than the like-for-like replacement value rather than maximum developable value of their land, or something that could achieve something in the neighbourhood. It was, you know, really, really, really difficult for all those landowners. There was also some people who had commercial properties in the same area. One of them in particular, they'd been offered, well, they thought they'd come to an agreement about the value of the fit out, and then they came back with an offer at half that value. And I'm not sure how that ended up playing out, but they were shocked and surprised because they thought they'd achieved an agreed value in that case. Then you get down to the other end of my electorate around Clyde, where a whole lot of businesses who are leasing government land had their businesses acquired over a 2-year period by Sydney Metro. Now, keep in mind the Russell Review really set strong parameters about this all supposed to happen within 6 months. And keep in mind that this area down in Clyde is only a couple of 100 metres from where the government paid, over the odds is, you know, the understatement of the year, but bought that property in Camellia and undertook all the remediation requirements in association with that property in Camellia at 4 to 6 Grand Avenue that they bought from Bill Berger. Nobody else has been that lucky. Everybody else has been treated in the absolute opposite way to that. You'll be talking to Mark Harold from Sydney Helicopters later today. I've been dealing with Mark for the last 2 years. I reached out to Mark when the Parramatta Speedway first started making noise about them being kicked off their site. I know the helicopter site reasonably well. I've never flown in there the helicopters, but I don't live very far away and they fly over my house all the time. So I contacted him. He had been contacted by Metro. And initially he thought that even though they were going slowly, that there was some goodwill there. They acknowledged that he has a unique service, that their business had been in operation for 25 years, that the relocation costs aren't exactly like for like because planning laws have changed. They would need a much bigger site now to be able to provide exactly the same service because there's rules about where you put fuel tanks in relation to takeoff and landing zones. And, you know, theirs is the only standalone helipad in Sydney, in the entire Sydney basin. So their site constraints are quite difficult. And it going on for 18 months, I'd written letters to many, many ministers, mainly to Minister Constance, but to others at different times. And they really weren't getting anywhere. They identified for themselves a suitable relocation site early in 2020 out at Penrith Lakes. It's zoned for tourism, and within that tourism zoning, helipads are allowed. So they've been quite keen to move there, even though it does compromise part of their operations. So most of what their business does is actually contractual work for the New South Wales government. A lot of it is firefighting. They do work for Sydney Water, a whole lot of different agencies. But they also operate tourist joyrides over Sydney Harbour. And being sort of at the head, close to the headwaters of the Parramatta River, is a really good place to sort of take off and land. When they found the site out at Penrith, there was a lot of obstruction going on. Metro thought they should just move to Bankstown Airport, despite Bankstown Airport being the busiest airport in Australia and the competitive advantage Sydney Heliport has. Sydney Helicopters has is that they don't have to spend money on waiting to take off and land, competing in the airspace with other aircraft. So moving to Bankstown Airport would really put them at a huge competitive disadvantage. There are other helicopter companies that operate out of Bankstown, and the real advantage that Sydney Helicopters has is that they don't have to wait and go, do fly arounds, all that sort of stuff before landing. So they found this suitable site. Metro was really difficult, and then it went on until the start of this year, when they were given a really pathetic offer for their business of about $800,000. Then that got raised to 1.8 for basically the business ceasing, or 2.8 if they moved to Bankstown Airport. They opted to go to the Valuer General. That process took months. In the meantime, they were supposed to vacate the site by the end of August, but they hadn't actually received their valuation back from Valuer General. In the last few weeks, they've got that valuation back. It was half of what they were talking about in meetings, and you'll be talking to them more about that this afternoon, but it's the way they've been treated is absolutely appalling. It's not just them, it's been replicated with other businesses on that street who all were stuffed around, found it very hard to communicate with Sydney Metro, received low offers, and I don't know where those ones are up to, but all of them have had exactly the same experience with dealing with Sydney Metro, and certainly the absolute opposite of the commitment we were given by the Premier when he was the Minister for Finance, when he implemented changes to the Act in accordance with the Russell Review. Throughout this period, I've asked for meetings with many, many ministers, and to his credit, the Premier is the only one who has ever met me about this at any point in time. So there's been so many ministers, and Minister Constance has been the worst. Even getting up in Parliament, he said, "Oh, well, come and see me." He still doesn't even reply to the correspondence himself. Everything goes to the PALSEC. Every response is completely dismissive. and completely rude and pretty much in keeping with the attitude of Sydney Metro to all my constituents, which is just ignore them until the very last minute and then insult them. The other one issue that I wanted to raise, and I raised in my further correspondence, was about the acquisition of land for a park by the Department of Planning and the City of Parramatta Council. So there's this small 6 homes adjoining one another in that North Granville area, in the area covered by the Parramatta Road strategy. The whole area has been rezoned for high-rise, and this small parcel of land, that's 0.39 hectares, was identified back in 2016 as the site for a park in this area. At that time, the Department of Planning gave money to Parramatta Council for the acquisition of that land. And people from the Department of Planning, together with Council, gave presentations to the residents, all the surrounding residents, but also the residents of those properties, and indicated that because they were being compulsorily acquired, they couldn't sell to anybody else. At the time, developers were making acquisitions and putting forward or making offers to put options on properties all around this area, and they missed out on all those, in some cases, absolute windfalls. In the meantime, also, Parramatta Council approved an upzoning of the property across the road, a very, very substantial upzoning from a floor space ratio of 4.5 to 1 to 6 to 1. Now, that was on the basis of an independent traffic study and also an incorporation of some of the affordable housing SEP and a few other factors. But those things always have flow-on effects. If you suddenly decide that the traffic impacts aren't as great as you thought and that this area can take higher development on one side of the street, there's always a flow-on effect. But there was always huge pushback about there being any flow-on effect whatsoever across the road to this parcel of land. There was a refusal to consider anything until the Parramatta Road Strategy's own traffic study had been completed. It's still not completed, even though throughout this whole parcel of land, Parramatta Council had increased the FSR on multiple properties based on traffic studies commissioned by the proponents of those developments. And then on the final day, so Parramatta Council sent out this very strange letter to people after I got involved in the process. It increased their offer by 10%, and they said that was a sort of a goodwill offer. Nowhere did it say that they're withdrawing from the compulsory acquisition process that they had everyone locked into for 4 years. And then on the afternoon, where everyone had to agree to it, and they were pretty much told, if any one party doesn't agree, then it's all off. And only at that point, that afternoon, did they actually say verbally, not in writing, that the compulsory acquisition process, they've withdrawn from it, and this is a take it or leave it offer. It was quite disgraceful. I've rarely seen anything like it in my life. I rang Minister Stokes. He did actually speak to me that afternoon and confirmed that, yes, there was a possibility that that money could be reallocated to find another bit of park somewhere else in that area, but they didn't have anywhere particularly in mind. It didn't have to be this site, but it had never been clearly communicated to those people that their properties were no longer part of a compulsory acquisition process. It was absolutely disgraceful. So that's a bit of a summary, and yeah, if you have any questions, I'm very happy to answer them.
Thank you very much for that comprehensive statement and evidence. I will start with the opposition. Is that you, Mr. Mookie, or Mr. Graham?
I might just lead in with this question. You've really covered a lot of ground in that introduction, and by virtue of your electorate, you've really been in the middle of a number of these projects. The bit I would like you to just rewind to and give us that perspective, given how many of these cases you've dealt with, is the position you're putting that after WestConnex, despite all those troubles, after the Russell Review, dealing now with Sydney Metro, it almost sounds worse. Is that the case? What's your perspective, having dealt with all of these issues?
Yes, it's absolutely worse. It's like the Russell Review never happened, apart from the 6-month parameter being adopted in relation to the comparatively simple acquisition of residential properties. The idea that you're supposed to have this contract manager and you're supposed to be kept in the loop, none of that happens. The communication is worse than ever. Now, in my experience, communication wasn't really a problem with RMS. They communicated with people, they just didn't listen to them.
Yeah.
But at least there was a one-way conversation. They talked at people. Metro doesn't even do that. They send you a letter, tell you your property is going to be compulsorily acquired, and then they run away, and then they come back at 5 minutes to midnight and give you a really bad offer that is just a complete insult.
And just one final question from mine before I hand to my colleague is, do you see that as a legal or a cultural question, or are there problems in both these spheres at the moment? Is there still more work to do on the law, or what you're describing sounds very much a deep cultural problem with the agency?
I think there is a very deep cultural problem. I think they are trying to just barely comply with the law where the law is very specific, so referring to 6 months. The things that aren't so clear in legislation, they just sort of skirt around. It's quite shocking the way they treat people, especially since there's been work done not very long ago to make this process better and fairer. And they've completely lost a sense of looking at the maximum developable value of the land as what is the basis for just terms.
Right, thank you.
Ms. Finn, one of the more novel points you've made, which we haven't actually heard, is about what happens when powers of the Act are delegated to councils and for councils to use. Do you have any sense that when these powers are delegated to them, there's any guidance provided to them about how the manifest discretion that's contained in the Act should be exercised? And what do you think are the broader lessons from the experience of the homeowners who have had to deal with the Parramatta Council, as you mentioned in your opening statement? How do you think we can improve it?
I don't know if they have provided sufficient guidance. That said, the City of Parramatta actually does a fair bit of acquisitions. Most councils are familiar with the Act. Most of them have a very long list of parcels of land which have been identified for future acquisition, and people know that. And when they, want to move out, they're obliged to try to sell to council in the first instance, or council can consider a compulsory acquisition if they want to bring forward that process. And that's usually how parks grow. I think I have a suspicion that the issue might be the same with both Metro and the council, that they had a certain bucket of money, and due to factors, well, maybe in Metro's case, less beyond their control, but due to factors that they didn't want to go back and ask the government for more money, they tried to behave in what isn't really, well, in an unjust way in terms of the terms that they offered people. I mean, Parramatta Council, different parts of Parramatta Council, obviously the development approval arm doesn't really think about the impact on the property section where they're acquiring property under the just terms compensation, when they've allowed sort of upzoning across the road, which does, in terms of maximum developable value of the land, very easily demonstrated that does have a flow-on effect. I suspect maybe the Sydney Metro paying so much over the odds for the property at 4-6 Grand Avenue in Camellia meant that they ripped off other people because they had a big leak in the bucket of money. And Bill Bergier did really well and everybody else got stuffed over.
Just on that point, it does seem that Bill Bergier sale was an anomaly in terms of Bill Bergier being able to I guess make a significant sum out of that to an extent that seems to be in sort of sharp contrast with what the average experience of people is. Given your experience with these acquisitions and with your constituents going through these acquisitions, have you ever seen, I guess, an offer, an initial offer, and anything like a fair value, or is it always sort of that kind of lowball offer to begin with?
The only one that wasn't completely lowball to begin with is perhaps the final VG determination issue with Sydney Helicopters, and the amount they were talking about then got reduced. And you'll talk to them more about that this afternoon. From a number that they thought, I think it was about 6.7 million, something that they thought was probably around fair value and certainly a starting point and a reasonable starting point, and then all of a sudden to get half that in writing was a big shock to them. But no, it's the RMS offers were much closer to fair value, like 5 years ago, than the offers made by Sydney Metro. Sydney Metro's offers are ridiculous. Like they're, not just not buying the same suburb, it's 10 kilometres away kind of thing, rather than offers that are, you could buy in the same suburb, but in the bits that are a lot further away from the train station where the house prices are much lower, but it's still the same suburb.
So for the average homeowner or small business owner, the initial offer is usually low.
Definitely.
Why do you think that is?
I think because they're trying to stretch the bucket of money as far as possible, and they come in low and just cross their fingers and hope people will accept it. It's really an appalling way to treat people when you're compulsorily acquiring their home. It's not like you turn up at an auction and hope there's no other bidders and put in a lowball offer. And these are not willing sellers. It's not fair. One thing I did notice looking at Bill Berger's submission is Bill Berger actually managed to have a lot of meetings with Metro about the acquisition of their property. And Metro don't talk to anybody else. Maybe this is why Bill Berger got so lucky, because they're actually fortunate enough to be able to talk to people and convince them of the value of their property, because they don't talk to anybody else. They just send them an insulting letter.
So do you think that then sort of evidences at least, if we're being very generous, a more relaxed attitude towards the sort of average homeowner or small business owner compared to big developers?
Yeah, I think they certainly think that they have less to fear through the average homeowner or small business owner taking them to court.
Thank you. I will just let the government members ask questions if they want to. Is that a no from you? No, that's a no.
I'm okay. Thank you.
All right. Thank you, Mr. Martin. Back to the opposition if you had a final question.
Yes, I do. I was just going to ask you, Ms. Finn, just in respect to the WestConnex issues which you have raised, those properties were providing your electric for the M4 widening project, that's correct?
Yeah.
And we're talking, what, quite a few of them, weren't we? How many are we talking about? Do you recall that you assisted?
I didn't deal with all of them, but there's about a dozen compulsorily acquired and another dozen acquired through negotiation.
And you've kept in touch with some of those families, or you're familiar with what's happened? Look, we haven't actually heard, and it is part of our terms of reference, as to what actually did happen to them after the acquisition, now many years hence. In your view, how are those families going as a result, and years after they lost their properties to that project in a compulsory acquisition?
The ones that I'm still in touch with, one of them who was compulsorily acquired, they bought another property a lot further away from the station and, you know, in a cheaper part of Granville. Their kids were at uni or TAFE back then. They're now out in the workforce. And I think the youngest got married last year. They're doing okay. The ones that went through negotiation were pretty exhausted by the time that it all finished, and all ended up moving further away. So I haven't spoken to them in a long time, but I have spoken to them since they moved out of the area, and yeah, they're a bit bitter about the process. The thing that really stuck with them was how long it took to actually receive the compensation payment after it had been agreed upon. And also because it was the voluntary process, they didn't get paid out their stamp duty or moving expenses, which is a lot of money in Sydney. And there's nothing that voluntary about moving out of a home that is cracking around you and has all the pictures falling off the wall, and RMS is paying for you to stay in a hotel because you just can't sleep with all that work going on next to you, or in a house that just doesn't have any sunlight to it. RMS have since sold some of those properties that they acquired because of the sunlight issues. They've sold them at quite a loss once they finished the project, and once they were, and none of them were sold to owner occupiers. All are now rental properties. No one is going to buy a house with no sunlight in the backyard to live in themselves.
I think our time might be expired, Chair.
Yes, I'm afraid so. So that does conclude. I don't think you took any questions on notice, but to the extent there are any supplementary questions, the committee secretariat will be in touch, and you'll have 21 days to respond. We are going to take a break until 12 o'clock, and then we will come back for our next session. Thank you, Ms. Finn.
No, thank you very much. Sorry about all the mishaps with the camera at the start.
No problem.
Thanks.
just check whether our next witnesses are coming in. Here they come. Hello to you both. Mr. Harold, can I check that you can hear me?
I can hear you.
Very good. You're a little bit patchy, but
Okay.
that might clear up. Let's see how we go. And Mr. McMillan, can you hear us? Mr. McMillan, are you able to hear us? We're having some audio issues. We'll just give him a minute to clear that up.
Hi, this is Adrian from Slater and Gordon. I can't hear anyone else.
No, we can hear you now. Can you hear us?
No.
But clearly you guys can hear me.
We can. Yes, we can hear you. That's okay. We'll give you a minute to sort that out. Not that you can hear me saying that.
This is very weird. Sorry.
Perhaps one of the Secretariat could give Mr. McMillan a call and see if we can work that out. Can you hear us yet, Mr.?
Oh, I can.
Oh, Mr. McMillan. Fantastic. There we go. All resolved.
I'm sorry about that, committee.
No problem at all. It's yes, we've had some issues today, so it's a relatively minor one. Let's get started then. So could I ask you first, Mr. Harold, to tell us your name, position, title, and then either swear the oath or the affirmation?
Yes, my name is Mark Andrew Harold. I'm the owner of Sydney Helicopters Group, and I'm here to give evidence, obviously, in relation to the parliamentary inquiry, to tell the truth, the whole truth, and nothing but the truth. I think that's what I have to say. Is there?
Did you receive the statement that the Secretariat sent?
Just let me have a quick look. I'm sorry.
That's okay. I'm trying to find my
copy
of it. Just give me 1 second.
Yeah, I do have it here. I'll just read it out.
Excellent. Thank you.
My apologies. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. Mr. McMillan, could you please state your name, position, title, and then swear either the oath or affirmation, please?
Sure. Adrian McMillan, associate at Slater and Gordon Lawyers, and acting for the Sydney Helicopters Group. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
That's fantastic. Thank you very much. Mr. Harold, could I invite you or Mr. McMillan, if that's your choice, to make a short opening statement. If you could keep it to 2 or 3 minutes, that would be fantastic.
Yeah, look, I do have something I will mention if you don't mind as a statement. It's about 3 minutes or so long. So since the 21st of October 2019, we've been, I believe, lied to. Our efforts to cooperate have been obstructed, and we've suffered enormously use of process within the Director-General's Department. I never expected to be sitting here speaking to you almost 2 years after we were advised of the acquisition, having received no compensation to date, and essentially homeless as we have had already to leave our property acquired. I was made aware of the acquisition on the morning of the 21st of October 19 during the Black Summer bushfires. We'd already been flying non-stop over 2 months and would continue flying for another 5 months on those fires. Our aircraft flew for a combined period of over 1,000 days, dropping 42 million litres of water, saving life and property throughout the state. I had no time to launch a media campaign like our neighbours to Parramatta Speedway, which ultimately saw Metro as applicants submit a DA that was approved the following March for a new facility at Eastern Creek, costing around $70 million. I instead believed in the process and believed in the lies that Metro representatives were telling me at the time. Property representative Mr. Houlihan said that in a meeting on the 23rd of October 2019 that we will be no worse off. Metro had met all the compliance costs relevant to our operation in 2021, that we would benefit from the status of the Metro project being of state significance, and that we would receive assistance with regard to the planning process. That Metro were committed to relocating us to property with the same characteristics as our current site. And in that meeting, I confirmed categorically that Bankstown Airport was not an option and would never be an option, having moved my operation there in 2006 already. I was urged on many occasions by Metro to find an alternative site. I identified the Sydney Olympic Park area and Penrith Lakes Development Corporation site, and other sites were discounted by the then appointed Metro aviation consultants on the grounds of those not meeting standards and conventions. The PLDC site in Penrith, although being some 30 k's further west of our current location, was identified in February 21 and is the most appropriate site in which to move our operation. And Metro approved the expenditure of required consultants to review that site, money that would later be paid through our compensation, which we're yet to receive. Metro were implicit in dealings at the Penrith site. The aviation consultant working for Metro, along with our appointed consultant, agreed on an equivalent facility that met all current planning, OHS, EPA and building standards. The Metro aviation consultant had taken the time to meet with me and take a brief on my operation. This consultant would later be removed by Metro once the report was tendered, replaced with a new consultant that made no attempt to communicate with me at all, instead taking a brief from Metro to relocate us to Bankstown. Our claim was submitted by Metro, once our claim was submitted to Metro, they abandoned all discussions on the Penrith site and instead moved to extinguish my business for $800,000, an amount of money, if accepted by me, would have bankrupted us and ended our operation altogether. At a meeting held on the 9th of September 2020, almost a year after we were advised of the acquisition, senior Metro staff confirmed that they needed to review our case further and would not communicate with us for a further 2 months. So that brought us up to December. Metro refused to respond to DPI requests for additional resources to process our application for the heliport at the Penrith site, resulting in lengthy delays and then later attempting to force us to go to Bankstown Airport, a site we'd already discounted. The matter was then referred to the Valuer-General in February 21, as Metro had made no attempt to negotiate our claim and rather adopting a dictatorial stance on where we should go or be extinguished. The Valuer-General process was long-winded and far from fair. Ultimately, the process for us would be summarised by the comments made by staff working within the VG department and telephone conversation with my solicitor following the final determination made by Dr. Parker, a director of the Just Terms team, wanted it known that he and the 2 valuers assigned to our matter had no part in the final determination. He believed that there had been an abusive process and that Dr. Parker refused to listen to their reasonings for just compensation. We had a strong and viable business with a long tenure remaining in our site, a site we developed as a commercial heliport providing tourism and essential emergency services over 25 years. I feel like we've been treated like the enemy from the outset. We are now left in a financially fragile position due to the compulsory acquisition, with no base from which to operate our full complement of services. The hypocrisy of the government has been overwhelming, opting to rather shut us down entirely only months after the state was ravaged by the worst bushfires on record.
Thank you very much, Mr. Harold, for that opening statement. I'm going to start with questions from the opposition. Is that you, Mr. Mookie?
It is, Chair. Thank you. And can I, Chair, thank the witnesses for making the time to appear with us this morning. Mr. Harold, can I just ask, did you create your business or did you establish it?
I purchased the company and the right or the interest in the land in 2006. The business then was a small tourism charter helicopter business, operating a couple of helicopters. And I'd previously been operating aircraft and supplying those to other operations since 2000. And I then opted to purchase the Sydney Helicopters Group in 2006 because it had effectively the heliport was the jewel in the crown as far as I was concerned. It was a point of difference, and it gave us the opportunity to then develop a very unique business, which we have done since 2006, developing the business from 1 aircraft through to now 9, and operating across a range of different services, including emergency services, search and rescue, fire, flood, and a range of other land management contracts that we have and services we provide, as well as continuing our tourism and charter activities, which has been obviously very difficult during the last 12 to 18 months with the COVID situation.
Right. I was asking questions of Metro yesterday about your case, and I've equally asked questions about your case in budget estimates. One point that Metro made to us yesterday was that they had provided you with a consultant to assist you, and that this, I guess, was offered as evidence of a spirit of cooperation or attempted cooperation on their part. But you've just said to us that they've gone through, what, 2 consultants, is it?
Yeah, so which consultant are they referring to?
A relocation consultant.
A relocation consultant.
To assist you in the process of finding an alternative site. Well,
we were offered a project manager, which we appointed in Collier's, project leaders, a chap by the name of Scott Anderson. Those fees, though, are ultimately coming out of our compensation, whatever that may be, at the end of the day. But we certainly did appoint them to assist us with a search for property.
But you had an initial consultant, did you not? I think from your submission, Mr. Lavis?
Oh, he wasn't our consultant. No, he was Metro's consultant.
Well, what did he have to do with this?
So Warren Lavis was appointed by Metro as their aviation consultant, and Warren Lavis took the time to meet with me and also our aviation consultant, a chap by the name of Steve Graham from Heavy Pro. And Warren took a detailed brief, if you like, from me on what my business, how it evolved, what my business was, how it operated, the revenue streams that we derive, and he then obviously went through a process of his own to then determine what sites would be applicable for us, and liaised with our aviation consultant at the same time. And Mr. Lavis did come up with a couple of alternatives that he himself actually, at the end of the day, discounted due to those issues in relation to compliance with aviation regulations and planning. It's my understanding that Mr. Lavis completed his report once he had finalised discussions with our aviation consultant as well on what would consist of an equivalent facility in today's terms. So if we were to move our operation today, and that report was then tendered to, his report was then, I believe, tendered to Metro. And we were then surprised to find that he had been removed as the aviation consultant for Metro and replaced with another individual that made no attempt to meet with me, no attempt to visit our site or that of the Penrith site. And I believe was given a brief to only consider Bankstown Airport as a viable option for Metro.
And when did Mr. Lavis's involvement cease?
Would have been around August, September of 2020.
And is that when you began to perceive that Sydney Metro's attitude towards your claim was changing?
Yes, it was, because we'd received a letter from Ashurst, the lawyers acting for Metro, at the beginning. I think it was the 7th of September, 2020, doing a complete about face on the proceeding discussions, if you like, around Penrith, and they opted to extinguish my business for $880,000.
Right. And you met with Sydney Metro. You said in your opening statement you met with Sydney Metro last September. What was the purpose of that meeting and what happened at that meeting?
So once we received the letter from Ashurst in relation to the extinguishment offer, I justifiably was very upset, and I contacted Tom Houlihan at Metro. He was our representative that would be there, the whole process, hold our hand the whole way. Apparently, according to him, his open email to us on the 21st of October 2019. I spoke to him and I advised him that how could they take this stance, that we had entered into a contract an agreement to purchase the land at Penrith. Metro had been implicit in those discussions since February or March of that year, being in some meetings with DPI in regards to furthering the planning aspects of that particular site. And it was only then that I received another letter from Metro withdrawing that offer of $880,000 because I had made it known to them that I was in a contract to acquire the Penrith site. I was then invited to come to a meeting and meet with Rebecca McPhee of Metro and their in-house solicitor and Ashurst lawyers, who were their external solicitor. Mr. Houlihan was there as well, and they asked, the meeting was to basically hear my side of the story, I thought. And at the conclusion of that meeting, Rebecca McPhee advised me that we would not hear from them again for a couple of months. They would cease all communications with us whilst they went away and did some homework on our matter, which I found completely and utterly unacceptable, given that the passage of almost 12 months had elapsed.
I just want to skip forward to the part where the engagement in the story with the Valuer General. And as I understand from some of the public comments you made, there was an initial valuation that was undertaken by the Valuer General's values for the tune of what, $8 million, was it?
6.7.
Yeah, and then after the intervention of the Valuer General, that was written down to what?
3.34, I think it was from memory. 3.34.
And did you have the opportunity at any stage to talk directly to the Valuer General?
I never spoke to the Valuer General himself. No, I was never given that opportunity to speak to him.
And you made the point in your opening statement that some members of the Valuer General staff then got in touch with your lawyer, Mr. McMillan, that's correct?
Correct.
So I might now turn to Mr. McMillan so you can give us some evidence on this. Mr. McMillan, this is to you. Mr. McMillan, what did the Valuer General's staff contact you to say?
They contacted me to give me a heads up that the determination was arriving that evening, because we had been waiting many months for it to arrive. So we received a preliminary report at the end of May. We met with the contract valuer and a member of the Just Terms team at Tuggerah in mid-June, and it wasn't until the 14th or 13th of September that we received the determination. So the call was a heads up to say it was coming. That person then said Mark is not going to be happy, and proceeded to set out that there was discontent within the Just Terms team, the contract valuer and the Valuer General's office with how Dr. Parker had intervened in the valuation.
Right. And have you ever been contacted in any like circumstance in any other matter, Mr. McMillan, to be contacted?
Never. I've never known a public servant to make a call or send correspondence to that effect.
So and correspondence was also sent to that effect?
Not to me. Correspondence was sent to Mr. Harold, setting out that. Well, sorry, it's not my evidence to give. That's Mr. Harold.
Mr. Harold, did you receive correspondence from any member of the Valuer General staff alerting you to what they perceived to be shortcomings in the valuation?
Yeah, I did. I received an email from one of the valuers within the Valuer General's department that had been managing our matter, and he, may I mention what was in the email?
Without naming the person, I think.
I won't name the person, no.
Yeah, but
I'll just pick out a couple of the salient sentences here. But he said the process from our end, process from your end or our end, could not have been better run or managed. From our first meeting at Clyde to our latest meeting at Tuggerah, you and your experts could not have documented or articulated your case any better. My personality does not allow me to stand in silence and watch events unfold in a way I believe is unfair or unreasonable. I've had my say and voiced my opinion at the highest levels, but in this case, at the end of the day, the Valuer General has total control of this process. I agree with you, Mark. Credibility is everything, as is reputation. With that in mind, I withdrew my support to how this was being managed some time ago when I could see and my thoughts and opinions would be dismissed without even proper discussion. So there's a couple of points there that he made known to me. I was very concerned about receiving an email like that from someone that clearly has a lot of experience in this area. I do know that this gentleman was involved with the Valuer General's department for a long period of time and was a very experienced valuer. And coupled with the other made to Adrian from the other gentleman, it leaves me with absolutely no faith in the system whatsoever. And a system that at the end of the day, we need to trust as citizens of this state. We need to feel that there is a process that should be followed. And in my opinion, it has not been followed at all. When you've got three gentlemen working on our case at a very detailed level being dismissed for the views of one individual who has had limited involvement with our matter.
My time has expired, but I was just going to ask if it's possible if you could table that on a confidential basis for the committee or forward it to us or consider doing so on notice. That would be helpful. And Chair, I was going to leave with a question, but I won't now. But the question was going to be to Mr. McMillan about whether or not the law permits business compensation, and how it's working in this particular case, which you might wish to ask in your time, Chair, if you do find it within your grace.
I may come back to you, Mr. Mookie. I just wanted to circle back on this issue with the valuation. What date was that email sent to you?
The 17th of September.
What action have you taken, if any, in relation to that, in terms of speaking with, what are your options, I guess, for complaining or for taking this to a higher level?
Chair, I don't know. My understanding is that the only avenue left for us is now to go to the Land Environment Court, which is a very daunting prospect for us when you consider that 2 years ago we were operating normally. This was not even on the horizon for us, and I'm sitting here now having already spent many hundreds and hundreds and hundreds of thousands of dollars that I have not been reimbursed for and will not be reimbursed for, even based on the current appalling determination from the Valuer General. I now need to go, I believe, to the Land Environment Court to have my case heard further. I don't know that there is an avenue for us to appeal the Valuer General's determination, and maybe Adrian can comment on that.
Please, if you don't mind.
Yes, thanks, Chair. Mark's right. The recourse is to the Land Environment Court, and we've issued an appeal pursuant to the legislation there. directions hearing is on the 15th of October. But that comes at a great cost. Any litigation is expensive. Any litigation is risky. There's no recourse to challenge apart from seeking a merits review in the Supreme Court, which would be lengthy, risky, and costly. That there's no way to provide any feedback to the Valuer General. We haven't been sent a survey or anything of that nature, and legally, the Land Environment Court is the way to go, and that's where we've gone.
And there's no provision to request a new valuation or some other sort of process that you can avail yourself of, just to confirm.
That's correct. The Valuer General, in very limited circumstances, can change determinations, but that is at his discretion.
Mr. McMillan, can I ask, when you received the communication you received from the valuer alerting you to an alleged interference by the Valuer General in the process, what was your response to that? Is that something you've ever seen before in terms of, have you had any previous inkling of that sort of behaviour occurring in the Valuer General's office previously?
Never, Chair. I was shocked. Shocked is the only way to put it. So just to give you a quick outline of the process, we received a preliminary report at the end of May, and that was for a figure of $6.7 million. And the contract valuer had assessed that Mr. Harold was entitled to relocation expenses to Penrith, but that he was only entitled to replicate what he currently had at his current site. We then met with them, with the contract valuer and a member of the Just Terms team at the contract valuer's office at Tuggerah to explain to them where we think they got the aviation evidence wrong. The aviation evidence is very complicated. Aviation regulation is very complicated. We felt we had a good hearing at that meeting. It went for about 4 hours. And following that meeting, the correspondence we got from the contract valuer and from the Just Terms team was that they had revised their valuation and that it was being sent to the Valuer General for his approval. We then got some correspondence that the Valuer General was seeking counsel's advice, which is not uncommon in my experience. And that led us to believe that the revision was a significant one in our favour by the contract valuer and the Just Terms team. Then a period of some months passed where, despite repeated correspondence to the Valuer General's office and the Executive Director at the Valuer General, that we were open to speak with him, we were open to explain the very complicated evidence to him. None of those offers were ever taken up. And we then received the call. I received the call, and then we received the determination of the final report with that $3.34 million figure, which the contract valuer or the Valuer General had said that Mr. Harold was entitled to relocate to Penrith, but a whole range of reductions had been made, which did not make any legal sense to me, and I have not been able to find precedent that supports those conclusions.
I'll just pass over to Mr. Banasiak in 1 minute. I just want to ask one final question. Was there anything, I'll start with you first, Mr. McMillan, was there anything in your negotiations or discussions with the Valuer General's staff prior to this notification, I guess, that there was or alerting you that there was an interference by the Valuer General? Was there anything in those previous discussions that led you to believe there were any cultural problems in the Valuer General's office?
Not from the contract valuer or the Just Terms team, no.
Thank you.
I had read the reports in the media, but they had not been expressed to me by those two people.
Thank you. And Mr. Harold, is that the same response for you as well?
Yes, neither of the two valuers that we met with had, let us know that there are any issues within the Valuer General's department. However, I was certainly aware of the issues that were made public, and in relation to Mr. Betts, I think it was, who was banning him from discussing in person with his other valuers in the department. So I think there was well, my understanding was that there was a directive not for the Valuer General not to speak to certain members of the valuation team, only to speak to a certain handful. So that was known to me, but those gentlemen didn't let us know.
So just to be absolutely clear, your impression from the communications you then had from the Valuer General staff were not motivated by any sort of malice or previous disagreements. They were purely concerned with the process.
Absolutely. And in fact, at the meeting in Tuggerah, the two gentlemen, because I asked the question, I said, well, what happens here? How does this get progressed? I mean, this is a second meeting we had with these two gentlemen. Obviously, the first meeting following the preliminary draft report, and they made it known straight away that there was no limit on what they could provide us in relation to compensation. It would be on its merits, and I left that feeling somewhat buoyed by the situation that finally after 18 months, 20 months, someone was actually listening to our situation rather than dictating to me where I should take my business that I developed, that I know intimately, that I know how it operates. And yet, I was told that I had to go to Bankstown or effectively shut up shop. So I was quite buoyed by the situation with the Valuer General's involvement at that time. I felt that the two valuers gave us a good hearing, and actually I was just reading the email that I'm going to tender with you later on, that this particular gentleman even said in his email that the meeting 2 at Tuggerah was not in vain. Our attendance at that meeting was not to tick some form of a box, but rather to give you and your team a genuine opportunity to convince us to change our position on the matter. The reality is that meeting was not initially in vain, but you know how the story ended.
Wow, thank you. Mr. Banasiak.
Yeah, just one question, Martin. In your submission, you say that the process or the negotiation process isn't really fit for purpose in matters such as yours. So if we were redesigning a process that was fit for purpose for commercial property acquisition, what, in your view, what would it look like? Based on obviously the deficiencies that you experienced.
Sure. Funnily enough, my background, I've actually done a Bachelor of Business and Land Economics, so I was a valuer. That was my training at university. And, I spent quite a bit of time around the property market over the years, as well as running a helicopter business. Now, my concern in regards to the way in which the Valuer General operates is that it's very limited. It has a very narrow view of how compensation is to be addressed. Notwithstanding the fact that my business is very, very unique anyway. I mean, there's no other heliport in Sydney, no standalone heliport facility in the Sydney Basin at all. The only aircraft that operate in the Sydney Basin operate from either Bankstown or Mascot or Camden airports. So it is a very unique situation. I believe that there needs to be a needs to be an ability for the Valuer General's office to determine the effect on business and how business is disturbed. So that's income streams coming from or coming to the business or not coming to the business as a result of the relocation, potential relocation, if you like. It needs to consider the different interests in land. I mean, we had a leasehold interest in the land. We owned all the improvements. We got the DA for the heliport. So all of that was created by us. Unlike, say, an office tenant that might occupy airspace within an office building, they don't own, the capital improvements. They don't own the building. They basically rent an office space. So determining a comparable in that example or that situation might be a lot easier than something along my line of work. So I think that we were very much caught up with a cookie cutter approach potentially with regard to the valuation of our interest and the valuation of our relocation. There needs to be a far greater emphasis on drilling down into the specifics of the business and the operation of the business, I believe, to provide adequate compensation. I mean, as it stands right now, the determination handed down by the Valuer General has left me short immediately of about $500,000 or $600,000 just on fees alone. Professional fees alone that I've had to incur as a direct result of Transport for New South Wales acquiring my interest in my site. Okay, now that's got to come out of somewhere. It's got to come out of my pocket, and that money should be otherwise invested back in my business. It should be there to ensure that I have a viable business with all my employees and we can provide the services that we were providing pre the 21st of October 2019. So, Mark, I think there just needs to be a much greater emphasis on compensating a business for business loss and that's to do with, time, inability to trade. I mean, right now, we're actually without a home and I've got no business disturbance whatsoever from this valuation, nothing. So it's an absolute kick in the teeth. I mean, I just ask you, all of you, to try and stand in my shoes for a minute, running a business, paying taxes, employing employees, investing in equipment that has a significant payback period, right? Providing services, essential services, and also tourism services, and particularly in a climate like now where you've got COVID that's ravaged the tourism industry. Just think about what it's like for us to try and navigate this situation that was never, ever contemplated by me 2 years, 3 years, 4 years, 5 years ago when I was making business decisions.
Thanks, Mark. I'll throw back to you, Chair.
Thank you. Mr. Mookie, I think we've got time for your last question, if you like.
Oh, thank you. How much do we have time for? A few questions, Chair, or?
I think we could at least squeeze 2 in if you don't mention the time.
I just want to put to you one view. Well, the first question is to you, Mr. Harold. In questioning Ms. McPhee yesterday, she made the point that they had offered you assistance in relocating to Bankstown Airport. Now, I'm not an aviation expert, and I know that this is a complicated matter, as Mr. McMillan has said. But can you just explain in really simple terms why you have to go to Penrith and not Blackstown?
Okay. As I sort of alluded to at the beginning there, my business, when I first bought the heliport interest and Sydney Helicopters, it was a very much a one-trick pony. It was a small business. It was a charter tourism operation, and I believe that the site itself, being positioned where it was, which was pretty much smack bang in the middle of the geographical centre of Sydney, would be a site that in years to come would become more and more important with regard to the movement of people around the Sydney basin. And I actually wrote a business case for buying that particular interest in land back in 2006, and it's funny, I pulled it out only about 6 months ago, and pretty much everything I sort of wrote was quite prophetic. It's come true. So The benefits for being located at Rose Hill, as opposed to Bankstown, were autonomy, the ability to operate outside controlled airspace, so no delays flying into and out of our base, which can be significant. If you are flying into a controlled aerodrome or out of a controlled aerodrome, you can be held up at the boundary airborne coming in, which translates to many, many hundreds and hundreds and hundreds of dollars in cost. And likewise, you can be held up on the ground before you're getting a clearance to depart the zone. So being outside controlled airspace is a very significant factor with regard to the way in which my business operates. Having good sort of transport links to the site were important, and Rose Hill, as is with Penrith, you had railway and road connections are good, and both those locations sit within demographics that are using our services and are readily accessible. So, in around Parramatta area, the Hills District and so forth, and it's obviously inland to the inner west. And my thoughts were that the Penrith side in time would also sort of be similar in that respect, given the push sort of out west for Sydney. The ability to manage our own fuel resources. So we have on-site fuel storage at Rose Hill. I'm buying fuel in bulk, which is saving me somewhere between 50 cents a litre, which is significant when you're burning 6 or 7 litres a minute in an aircraft. So those issues were significant. And also just, the amenity and the feel of the place, the ability to have your own identity, your own feel at the heliport was significant, and you can't generate that at Bankstown. Bankstown is an old aerodrome with essentially support infrastructure there, so support services, maintenance, avionics, the odd flying school, mainly fixed wing operations, and the helicopter operations are ostensibly government related. They have no commercial consideration whatsoever with regard to attracting clientele. And running a tourism operation out of a Bankstown facility would be impossible to the level that we were running it out of Parramatta, and that I believe we could ultimately run it out of Penrith. Look, I don't want to speak poorly of Bankstown, but it's not. It doesn't have a culture. It doesn't have a feel about it that's actually very inviting. The airport itself, and I do know a lot of operators there that are also, discontented in their training schools. They're not tourism operators. You've got a couple of training schools, and you've got the police air wing, you've got national parks, and you've got New South Wales Ambulance operating there, and Care Flight. So there's no one like us. We're not a one-trick pony, as I said before. We have multiple facets of income coming in from where we are based, and I believe that the Penrith standalone facility, a heliport, not an airport, that's comparable, is the way to go for us. And it was outside controlled airspace. The Penrith site is outside controlled airspace, zoned to tourism, and it already has permissible uses of helipads under the planning instrument.
I was going to ask Mr. McMillan whether he wished to comment on whether or not leasehold businesses are entitled to compensation in his experience. But I'm at your discretion, Chair, as to whether we can fit this in or whether Mr. McMillan should be invited to take it on notice.
I think, in fairness, we should probably ask him to take it on notice. We have gone 5 minutes over, but I think it has been a very, very useful discussion with you both. Thank you very much for coming and giving evidence. Yes, to the extent that there are supplementary questions or any questions taken on notice, the committee secretariat will be in touch, and you have 21 days. So that ends this session. We will be back in 5 minutes' time for our final session of the day. Thank you.
Thank you very much. Appreciate it.
Good afternoon, Mr. Parker. Can you hear us?
I can. Can you hear me?
Yes, I certainly can. Thank you very much for attending. I will get us started. I'll just ask Mr. Parker if you could please state your name and position title, and then either swear the oath or the affirmation. Can you hear me, Mr. Parker?
I can hear somebody else as well.
Is there perhaps were you watching the live feed before? There might be a live feed still going on in the background.
I think it probably was. My name is David Rowland Parker, and I'm the Valuer General of New South Wales. I solemnly, sincerely, and truly declare okay, let's have a look.
You may need to turn off the other.
I think that may have fixed it. Shall we try again?
Yes, please do.
My name is David Rowland Parker, and I'm the Valuer General of New South Wales. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Fantastic. Thank you very much, Mr. Parker. I'd like to invite you to make a short opening statement if you wish.
Certainly. Thank you, Chair. Now, as Valuer General, I'm an independent statutory officer appointed by the Governor of New South Wales to oversee the state's land valuation system. I report to the Parliament through the Joint Standing Committee on the Office of the Valuer General. As Valuer General, my role is to be independent of government and of the dispossessed, and to be fair to the parties. I'm required to determine compensation to be paid to the dispossessed in accordance with the Land Acquisition Just Terms Compensation Act, court precedent, and Valuer General policy. Now, it's important to note that before a compulsory acquisition matter gets to me, there's been 9 months of negotiation between the parties, being the statutory 6-month period, followed by the further 3-month period. So there's been a long period of time in which the parties can reach agreement if they're able to do so. When agreement can't be reached and the compulsory acquisition is gazetted, the matter is referred to me to make a determination. Now, I stress that is a determination. It's not a mediation or a reconciliation between the parties, but it's an independent determination. So to do that, I make a de novo valuation, I assess the disturbance claims of the dispossessed, and I assess the other heads of compensation. I do that with regard to the provisions of the Act, court precedent, of which there is quite a lot, and Valuer General policy. I read the claims submitted by the dispossessed and the issues list submitted by the acquiring authority, and we exchange that information between each party so that there's no risk of adverse information. When completed, a preliminary report is provided to both parties for consideration before I finalise my determination. I have a series of conferences for the parties during the process, and it's very common for my determination to differ from the claim made by the dispossessed or the offer made by the acquiring authority. If the dispossessed is unhappy with my determination, they have a right of appeal to the Land and Environment Court, but the action in the court is between the dispossessed and the acquiring authority, and it doesn't involve me. I'm told and advised by the department that in 2020-21, 5 matters were determined by the Land and Environment Court, so matters going to court are relatively few. In 2021, there were 88 determinations, so it's a pretty low percentage. And I'm told by the department that 65% of determinations were issued within the statutory 45 days, with an average time taken to issue a determination of 81 days. Now, since I was appointed, as the members of the Joint Standing Committee would know, I've made a variety of changes to the management of the compensation determination process with a view to speeding up the time in which determinations are issued.
So when I arrived, the average was 177 days. I'm advised by the department that last year the average was 88 days. So the average time is falling. Since I arrived, I personally intervened to clear up over 3,000 substratum determinations for railway tunnels, and significantly 8 claims by Indigenous groups for cultural loss that had been lodged from around 2015. Last year, and then again this year, I proposed initiatives to the Joint Standing Committee for restructure and speeding up of the process in order to maintain procedural fairness, but avoid doubling up on the Section 34 conference process in the London Environment Court. These changes are currently underway, and the department has recently appointed an Executive Director of Business Performance to oversee business improvements and the transformation of systems and processes to support me in meeting my statutory obligations. Now, I'm aware of community interest in issues such as my independence, conflict of interest, stamp duty, relocation, Sydney Metro, Orchard Hills, Riverwood, Sydney Helicopters. I'm happy to address each of those if the inquiry wishes, but in terms of an opening statement, that's probably enough for the moment, and I'm happy to attempt to answer any questions from members.
Fantastic. Thank you very much, Mr. Parker. We will start with questions from the opposition. Mr. Mookie.
Thank you, Chair. I will be short, sharp and pertinent, Mr. Parker. Good to see you again.
And you, Mr. Mookie. Good afternoon.
Last time we had the opportunity, with Mr. Farrell and I had the opportunity to talk to you, was at the Standing Committee. And at that time you said you alleged that you were subjected to political interference by the government, and reported that you had been ordered by the then Secretary of the Department of Planning and Environment to only speak to 4 of your 120 staff. Is that order still in place?
Well, I might just clarify that it wasn't political interference from the government, it was administrative interference from the department. And yes, that order is still in place. It was recently widened to include a range of directors. So it's a slightly larger number now.
Oh, okay. So how many people can you now communicate with?
Off the top of my head, I think we would have gone up to 8.
8 out of 120 staff?
Yes.
Yes. And have you since cancelled any of the delegations that you've made to your staff?
I have withdrawn delegations to the Just Terms team and brought all Just Terms valuations to come before me for review prior to issue.
So no one in your office other than you has the authority to finalise a determination. Is that the result of your decision in layman's terms?
No, there are 2 other parties, the Deputy Valuer General and I think it's the Director of Valuations. Both have a delegated authority to make determinations.
And when did you make that decision?
It would have been, I can check the exact date for you and come back to confirm, but would have been a couple of months ago, 2 or 3 months ago.
And how many members of the Just Terms team are there in the office?
I think from memory there are 6 valuers and 3 administrative staff.
So 8%, 9% of the office?
Roundabout, yes.
Yes. And they have lost the authority to complete determinations?
No, they still complete determinations. They have the authority withdrawn to issue determinations.
Right. And on to questions that I asked the Minister for Property on notice, reported that 2020 to 2021, you completed 4,000 or 3,909 compulsory acquisition determinations. Does that accord with your experience too?
The number sounds broadly correct. I think some 3,200 of those would be substratum acquisitions for railway tunnels.
So it's about 700 which are not substratum, thereabouts. Is that fair?
In which year was that, sorry, Mr. Mookie?
2021.
2021. I was advised by the department that in 2021 there were 88 determinations issued.
Well, they told me that in 2020 to 2021 you had 3,909, and you just said that 3,200 of them were substratum. So the implication that I draw is that one of us has been given the wrong figures by the department.
That would be a reasonable inference to draw.
So I'm working off the assumption that the answers that's been given to me by the minister would imply that there were 700 that year, which is up from 128 the year previous. And that 128 would also include substratum. My only point in all this is, given that you've withdrawn the delegations, shouldn't we be really worried that if you're the only person who can issue a determination, then every business and every resident that's going to be coming to you is going to experience pretty significant delays?
No, I don't think you necessarily should be concerned. The large bulk, if there are substratum in a year, and of course that depends which acquiring authorities are building tunnels, are a single letter. So the approval process for that is measurable in seconds.
Okay. Look, my last question.
The other determinations come in, or are currently coming in, at a rate of 2 to 3 a week. We have myself, the Deputy Valuer General, and the Director of Valuation Quality Assurance, all with authority to issue them. So there should be no reason why we couldn't finalise 3 properly prepared determinations each week.
Okay. Look, my last question before I pass to my colleague is, why did you take this rather extraordinary decision to withdraw the delegations to the members of your own staff?
Because I started reviewing valuation reports and became extremely concerned at the level of, let's use a nice term, issues arising.
What issues are you talking about, Mr.? You don't need to be diplomatic, Valuer General. Like, be blatantly straight with us. You were last time we spoke to you. What issues arising led you to withdraw legal authority to the Just Terms team to issue determinations?
The extent to which determinations were not compliant with VG policy, court precedent, or the Act.
I'll pass to my colleague.
Thank you, Valuer General. I might turn to a specific issue. Have you released a final determination for the 5-dock pharmacy?
No, I have not.
And why has that matter not been finalised?
Because the matter raises an issue over whether or not a buyout premium is compensable under United Petroleum. I've taken advice from the Crown Solicitor. I've taken further advice from the Solicitor General, and we are currently doing some further research to form a view prior to me finalising the determination. It's an amount of approximate magnitude of $400,000, so it's a significant amount for both the claimant and for the acquiring authority.
And the advice that you're provided by the Crown Solicitor, did that indicate that it was or was not compensable?
It indicated that the decision was mine and would rest on the particular characteristics of the individual matter.
And did it give any indication about, while it left the decision with you, did it give any indication about whether it was likely compensable?
It gave a view that based on the information that had been supplied, it was likely compensable. We're now in the process of clarifying whether the information supplied was correct.
And in relation to the Solicitor General's advice, did it indicate that it was likely compensable or not?
Yes, on a case-by-case basis, and again on the basis of the information with which the Solicitor General was supplied, it was his view that it would be compensable. So we're clarifying and confirming that information.
And in your view, given that you will make this final determination, currently, is it your view that this matter is compensable?
There is an argument that based on the unusually long lease that the claimant had in his original premises, there would be a basis for compensation. It is still unclear whether other existing vacant shops could have accommodated the claimant, and that's what we're clarifying at the moment.
Yeah. So, I mean, that sounds like you're much less convinced that this matter is compensable. Is that a fair statement?
No, I'm concerned that it is $400,000 of public money that I wish to be sure we are correctly spending before I make the determination.
How long has this process taken so far?
It would have been with me for approximately 2 months.
That's with you. How long has it been with the Office of the Valuer General altogether?
I'd have to take that on notice.
And when will you be issuing the final determination so that this claimant actually has some certainty?
When DPI staff furnished me with the information that I requested late last week.
And when do you expect that to be?
The DPI staff are managed by DPI, the responsibility of the executive director in DPI, so I have no control over the DPI staff.
And finally, I might ask, in your time, you would have certainly recommended that some valuations be reduced. Have you ever recommended an increased valuation?
I haven't yet made any changes to matters of judgment where an increase in valuation is more likely to arise. I've been more dealing with compliance with the statute, precedent and policy, which generally is whether or not something is compensable or not. So if it's not, the amount would go down. But at the moment, we haven't started looking in detail at the individual valuation judgments.
Have you ever added to the list of matters that are compensable?
No, because the claimant provides in their claim what they consider that should be compensable to them.
I might hand to my colleague.
Mr. Parker, can you update us as to what is the status of the allegations of bullying and harassment that have been directed against you?
I was unaware of any allegations of bullying and harassment.
We went over this matter quite extensively when you appeared before the Joint Committee.
A point of order, Madam Chair. I don't think that the nature of Mr. Parker's role is within the terms of reference of this inquiry. Now, of course, Mr. Mookie and myself both were engaged in the Valuer General Committee, and I think it's a fair question there, but I don't think it's really a fair question for this inquiry.
Well, can I just rephrase that, perhaps, to bring within the terms of reference? Mr. Valuer General, at the committee that Mr. Fowler just made reference to, you made the point to us that you were subjected to allegations of bullying and harassment from the Just Terms compensation team. We did spend some time exploring whether or not that was in response to the reforms you were making. Can you give us any update as to how that process has resolved?
The Just Terms team are employees of the department and they're managed by the executive director of the department. So I have no contact with the Just Terms team.
Okay. Equally, you made the point then that some of the matters that were raised by the Just Terms team were then going to be subject to a meeting that you were going to have with the minister at the time, or shortly thereafter our hearing. Can you give us any update as to whether that meeting did take place and what the outcome of it was?
The meeting did take place and the minister was very supportive.
Okay. Equally, you made the point that you didn't think that your decision to revoke delegations would lead to any delays, because I think, as you just put it, 2 to 3 days, you get a letter, that's usually it. But I struggle to reconcile that Valuer General with the evidence that the Minister has provided us this year, which says that the average time for compulsory acquisition determinations made by the Valuer General were 221 to 222 to date, which was a date as of 16 August 2021, was 118 days, which is well outside the statutory limit, and an increase, according to the Minister, close to 40 days since last year. I just struggle to reconcile how your claim that this, for want of a better term, strife in your office isn't impacting on businesses or residents, when the data that we have shows that the time it's taking for your office to determine matters has gone up by 50%.
Well, it's not my office. It's the
okay, well, to be
staff
fair,
the staff are DPI staff managed by DPI. However long they take to produce a determination to give to me to review is a matter for DPI to manage. It's beyond my control.
But Value General, the Minister says in her answer, this is what she says: it's off the compulsory acquisition compensation determinations made by the Valuer General. The average number of days to process the determination was 2020, 21, 81 days. 21, 22 to date, 118 days. It's clear that this is evaluations that you're making. Is it your evidence that you are being delayed because DPIE staff are not handing you the information you need in a timely way?
In essence, yes.
And what steps have you taken since to resolve that?
I have proposed a restructure program, and DPI have appointed an executive director to implement that restructure program.
And did that take place with your consent, or was that against your wishes?
No, that was my proposal that DPI is implementing.
Yet we still are in this circumstance where you are only capable of talking to 8 members of staff that are attached to your office, or okay.
So can I just clarify, they're not attached to my office. They are DPI staff managed by a DPI executive director. I have no staff. I'm reliant on DPI staff managed by DPI executive directors.
But prior to your engagement as Valuer General, these staff were seconded effectively to the Valuer General's office. Is that correct?
It is.
So since you've become Valuer General, the secondments have been terminated.
The rearrangements resulting from the Secretary's letter of the 10th of May have the effect of me having no control over the staff. So I have no control over the timing with which things are delivered. That is entirely a matter for the department and the relevant executive director.
Sure. I'll leave it there, Chair.
Thank you. Can I just pick up on that then? So just to clarify, you said before that there were 6 valuers who were previously delegated to issue determinations. Is that correct?
That's correct.
And they are all DPI staff?
They are.
Is it within your role or within your power to suggest improvements to the quality of the work of those valuers?
It is within my power, and under the Secretary's letter of the 10th of May 2021, I raised concerns with the Deputy Secretary, and the Deputy Secretary may take action, if any, as he considers appropriate.
So what steps have been taken then to date since you took the delegations away from those 6 valuers to get the situation back to what it was? How far away are we from you being able to issue that delegation again to those 6 people?
I don't know how far we are away. All I can repeat is that the department has recently appointed an executive director of business performance to oversee business improvements and the transformation of systems and processes to support me in meeting my statutory obligations.
Is there the issues that you identified in the determinations of those valuers that you spoke of before? Is there scope for different interpretations of that work, or is it very clearly, I guess, is there something that, can you very clearly state that those valuations did not meet quite transparent obligations on those valuers to consider?
In the majority of cases, it would be straightforward, black and white. I accept there are a minority where particularly the United Petroleum decision and more recently the Eureka decision leave an area for interpretation. Usually in that circumstance, I invite the Just Terms team through the executive director to basically put their case as to why in this circumstance they feel this should be paid.
And in those circumstances, what, I guess, a ballpark percentage of times would you accept that explanation? If you've identified that there's something that's perhaps open to interpretation and you ask for that explanation to be put to you, in what percentage of those occurrences would you then say, oh, okay, I understand, I accept your interpretation, versus the one that you have drawn?
Probably pretty close to all of them from memory, thinking over the last couple of weeks.
Okay, and longer than that?
Well, I've only been reviewing reports for about 3 months, and it has taken a little time for reiterations to come back to me.
So in the case of Sydney Helicopters, from your evidence before, can I surmise then that the reason why that valuation was lower than what had been originally suggested is because there were items in there that you viewed as not being compensable, that had been viewed as compensable by the primary valuer?
Yes, there were two strands of issues. One was the fundamental way in which the claim had been treated, and the other was the nature of compensable items. So I finalised that claim in association with the contract valuer. Essentially, the claimant was dispossessed of a 570 square metre light industrial building with some helipads, taxiways, fuel storage area. He was compensated for a 570 square metre light industrial building with helipads, taxiways, fuel storage area.
So just to clarify then, in that case, were you aware that there was a disagreement with the contract valuer? And was there, I guess, did that come down to an interpretation issue as opposed to a sort of a hard rule?
I think we probably need to be clear here that the contract valuer, in the sense of the valuation contractor, the independent party who does the work for the Valuer General, and I were of the same opinion. The valuer contracted to work for the Just Terms team was of a different opinion.
I see. Thank you. I'll hand over to Mr. Banasiak.
Thank you, Chair. Noting the seemingly convoluted relationship you have with TPI staff at the moment, and try and put that politely, what's your understanding about their previous experience in doing this work, in particular whether they've worked in the private sector doing evaluations on compulsory acquisition?
I'm unaware of the previous employment history of the staff in the Just Terms team.
Okay. What's your understanding of the level of training that is provided to them as part of the Just Terms team, noting that you've put forward a suggested reform process to improve their performance? What's your understanding of their level of training in this area?
They should be the state's leading specialists on compulsory acquisition valuation. They should have a bachelor's degree or equivalent, given that some may have joined the public service when things prior to the bachelor's degree were enforced. So they should be academically qualified valuers. There's certainly a lot of experience. They are members of the relevant professional body, and there's a variety of levels with differing levels of responsibility for differing complexity of work. So,
okay, so we heard yesterday, I think it was through questioning from the government. It was Peter Regan said that that they still have to work to a budget, or they have a budget for these compulsory acquisitions for projects. Does the compulsory acquisition team, to your knowledge, get notice of what these budgetary restrictions would be, and how much of a impact or effect does knowing what those budgetary restrictions are play in an evaluation?
I was unaware there were any budgetary restrictions, in that my understanding was that in my preparation of my determination, I would spend whatever was required to make that determination, and it will be reimbursed by the acquiring authority.
Okay, that's your position. What's your understanding of the Just Terms team and then their knowledge of a budgetary, a budgetary cap for an overall project?
I can't answer that.
Okay.
But just on my part, it would be an anathema to have any form of budgetary constraint, because I couldn't exercise my independence if I was limited in any way. So I couldn't afford to take advice I thought was necessary to complete evaluation. So it would be simply unacceptable.
Would it concern you if you heard that these DPI staff that are acting, I guess, as a satellite to you, are taking into account some sort of budgetary cap for an overall project?
It would be a matter I'd wish to raise with the Group Deputy Secretary, yes.
Okay, thank you. I think that's pretty close to my time, so I'll throw to the government.
Just to pick up from Mr. Banasiak's point there, I guess it was all a case of hypotheticals, but is that something you have any actual knowledge of or any suspicion of, so to speak? Or
no, I don't know. I was unaware of it till Mr. Banasiak raised it.
Okay, fair enough. Just wanted to cover that off. Mr. Parker, with respect to some of the evidence we've heard today, I think the Law Society was saying earlier this morning that one of their concerns, at least not necessarily from an institutional basis, but from their own personal experience, has been the delay in terms of valuation periods. And one of their suggestions was valuations really need to be relevant to the time period. And even in this environment, a delay of 3 to 6 months in evaluation would be quite pivotal in terms of the true market value. Is that something that you'd share that opinion of? Or?
Well, the valuation was as at the date of gazettal, so I can fully appreciate if there is a gap between gazettal and determination, the market may have moved. So, for example, a house owner, if their property is gazetted on the 31st of March, they receive the valuation as at the 31st of March. If they don't receive the determination until 30th of June, then the market may have increased and they may be able to buy less house at the 30th of June than they could at the 31st of March.
So your suggestion largely there is that it's not necessarily the property itself that is the challenge there, but then what you can use that money for in the market as the market moves. Is that correct?
Yeah, I mean, that is a fundamental challenge in compulsory acquisition, in that government acquires an item from a party with no regard to where the party is going to go next. So I read in the submissions of regular concerns that people have their houses acquired, they receive X dollars, they can't buy a house close to where they live for X dollars. But that's one of the unfortunate policy consequences of the current approach to compulsory acquisition.
Now, Mr. Parker, I know prior to you entering this role, you had a very broad experience, and just looking at your LinkedIn profile, seeing your sort of international experience, so to speak, as an expert on this topic. Are there, not necessarily with your valuer general hat on, but with your prior experience, are there other systems that have been undertaken by other governments or other regulatory regimes in place that have perhaps captured that challenge?
Not that I'm aware of, and pretty much every regulatory regime, generally across the Commonwealth, because they're the easiest ones to compare with, have some more advantageous features than ours and some more disadvantageous features than ours. So regrettably, there doesn't seem to be a system anywhere in the Commonwealth that everybody says, that works really well, we should do it that way. So unfortunately, no.
And now the committee has also heard a lot of criticism in terms of those whose properties are being acquired with respect to market value and the definition under the Just Terms Act under Section 56, that it is at that point in time and doesn't anticipate sort of the future value improvement that may be captured if, for instance, there was a metro station to be built on a particular property. Just interested in your perspective, if that were to be amended, is that something that would be possible for the Valuer General's office to be able, and yourself, to be able to fully capture that sort of uplift in the market if there was some sort of definitional change, or is that a huge impediment in terms of the process of valuations?
No, I issued a report last year on the impact of rezoning potentiality on value. We now take into account rezoning potentiality consistent with half a dozen London Environment Court cases. I mean, as with any aspect of legislation, if government is of a mind to implement that, then we will find a way to deal with it. There are some broader policy issues, enrichment and things like that. The fundamental tenet of compulsory acquisition, which is to disregard the scheme. They could be worked around in the legislative process.
And with respect to the reforms that you've said in terms of the acquisitions team, when do you think you'll see them fully realised in terms of, and I imagine that question comes back to DPI as well, with that staff under DPI, but do you have any expectation as to when those reforms will be fully enacted and in place?
Unfortunately not. No, I can repeat the paragraph again that DPI gave me. Recently appointed an Executive Director of Business Performance to oversee business improvements and transformation of systems and processes to support me in meeting my statutory obligations. And it's a matter for DPI when that is done.
Thank you, Mr. Parker. I'll hand over to my colleague, Mr. Martin, if he has any further questions for you. Thank you.
No, I think unless Mr. Graham's got one additional. Yep, go ahead, Mr. Graham.
Can I just ask, in relation to the Sydney Metro project, some of those properties, have you or any of the staff have met with Sydney Metro before the Gazette?
I issued instructions that the valuers were to cease meeting with acquiring authorities on individual matters, but that the Director Just Terms team could meet with acquiring authorities on a periodic basis to understand the extent of projects that will be coming up. So there should only be a periodic meeting between the Director Just Terms and the acquiring authority in terms of impending workload, and the only interaction between the acquiring authority and my staff should be through the conferences that are part of the acquisition process.
Right, thank you. And can I just ask about two particular determinations? The Any-Shape Plastics business in Clyde is still waiting for a final determination since 19 March 2021. Is there a date for final determination there, and also for the Hospitality 2020 business in Clyde?
Now, I thought, and I may be wrong, but I thought the Any-Shape Plastics, all the preliminary determinations had been issued. And therefore, we will be waiting to hear back from the claimant. I can make further inquiries about that just to find out what's going on.
If you're able to take those on notice, that'd be helpful.
Yep. Yeah.
Thank you. I might hand to my colleague.
I was going to ask you a question, Valuer General, about the Sydney helicopters matter, which I presume you may have seen the evidence that they gave.
I did, yes. Yeah.
So, I mean, they read to us from a rather extraordinary email that was sent by one of the contract valuers, or the valuers in your office, and then reported on a phone conversation that was had with them too. I mean, it's highly alarming when we have witnesses telling us that they've been contacted by people, for want of a better term, at least under your control, or at least involved in the process that you are, that are alleging that you interfered. And equally, that same person is telling us that he never had the opportunity to talk to you directly, and he can't see any process by which you tried to understand the individual circumstances of his business. Do you wish to respond to that?
Yes, I mean, let's perhaps deal with those sequentially. In terms of interference, as I'm the Valuer General, and the Valuer General issues the determination, there can be no interference. In the minds of the Just Terms team, they may be of the view that they issue the determinations, but the Act is very, very clear. I issue the determinations. Therefore, the process is entirely up to me. In terms of the comments made by Mr. Harold, I'll wait for the transcript to be published and refer it to the Deputy Secretary or Group Deputy Secretary to take further within DPI, because I agree they are remarkable allegations.
Mr. Parker, what about Mr. Harold's claim that he never had the opportunity to speak to you, or he could not see any process that you had engaged in independently of the work of those who you now, well, effectively are implying perhaps were exceeding their authority, and to determine the individual circumstances of his business? He said that he feels like he was the victim of a cookie cutter process by you now, given you issued the determination. Do you wish to respond to that?
Yes, the Just Terms team will meet with claimants in conferences. That is our established process. I have not, since I've been appointed, met with any claimants or with any acquiring authorities on particular compulsory acquisition matters. So I was unaware of any attempt by members of the Just Terms team to seek meetings with me to raise issues. They have the ability to do so under the Secretary's letter of the 10th of May 2021, where they can be accompanied by the Executive Director, but I was unaware of any of them seeking to do so.
But Mr. Parker, from the perspective of Mr. Harold and his business, it just seems like he's been caught up in an internal battle of some form that's taking place in your office that has nothing to do with him. And as a result, it seems like he had a valuation written down by half by a person who he's never had the opportunity to talk to. Can you understand from his perspective why he might see this as a deficiencies in the process?
I understand that Mr. Harold spoke to the independent external contract valuer who did the valuation that I relied on.
But disagreed with. I mean, the preliminary...
No, just to clarify, the independent contract valuer agreed with me.
Well,
his
the preliminary...
Internal contract valuer, I believe, was the one referred to in the Daily Telegraph and Sydney Morning Herald.
Okay. Look, Mr. Parker, he says that the preliminary determination he received from your office had his compensation at 6.7 mil, and the final determination which followed your intervention was written down by half. Can you explain what additional information you had access to that led you to write down the value from the preliminary determination that was given to him and the final determination that was given to him?
Well, it wasn't written down. It was probably incorrectly stated at 6 point whatever. I simply had regard to the facts that were provided in the independent contract valuer's report, the case law as it stands, the requirement of the statute, and applied those to the circumstances of this matter, and the answer that came out was in the order of $3 million.
Chair, I think the time might have expired, or not?
Yeah, I think it has, but can I just clarify that one little point, because it comes back to a question I asked previously. Are you saying then, Mr. Parker, that that was because there were certain items that you viewed as not being compensable, but had been viewed as compensable by the DPI employed valuer, or
Yes,
did you value those items differently?
No, it was included items that I considered not to be compensable based on case law and valuer general policy, and it also had concerned a different approach to the valuation.
Okay, thank you very much. Unfortunately, that is all we have time for today. Thank you very much for making yourself available, Mr. Parker. We really do appreciate that. To the extent there were questions taken on notice or there's any supplementary questions, you'll have 21 days to respond, but the committee secretariat will be in touch. That does end our hearing for today. Just to let members know, there will be a short deliberative once we are no longer live, but we will say goodbye to you, Mr. Parker. Thank you very much.
Thank you very much. Good afternoon.
Okay.
It should work.